All right.
Yes.
Well, I just lost them for a minute here, so we're off to a blazing start. Delgado Rosales versus Carvajal Gonzalez. Both parties are present via Zoom. This is a motion that was set today by the defendant father. Says, quite frankly, there's an order for him to pick up the kids for Thursday parenting time after school. He says he just can't do it. He's not available. He has also filed a de novo, I think, with Judge Hillary. Isn't that correct, sir? Has that been heard? Mr. Carvajal?
Somebody speak Spanish because I have I need it
You need an interpreter?
yes.
We call in. This is not the case you originally called for, but Mr. Miguel Carvajal indicates that he needs an interpreter. Ma'am, do you need an interpreter too?
Señora, ¿usted también necesita un intérprete?
No, yo no.
I've introduced the case, said that this is father's motion.
Señor Carvajal.
Says he can't pick up the kids on Thursday, which is the order, once every other weekend from Friday through Sunday. And he also wants some time on the 4th of July, Thanksgiving, and Christmas Day. Ma'am, what's your thoughts?
No.
Señora, ¿qué piensa?
No, what?
Christmas, the whole Thursday through Sunday, I don't understand why can't he make time to spend with his kids. I'm not asking for a lot, to be honest.
I believe, Mr. Carvajal, are you still appealing this case to Judge Hillary?
Sí.
Yes.
Well, then there's really not much I can do with it right now. We'll wait to hear what the judge does with his appeal.
Entonces,
as far as your request for additional time, 4th of July, Thanksgiving, and Christmas, I think we'll wait for everything and see what happens with Judge Hillary's appeal. You have a time that it's set for in front of Judge Hillary yet?
No, they just gave me this paper, but they didn't tell me when.
All right, follow up with Judge Hillary's office for your appeal. Any other matter? I'm just going to leave it in place that it goes from Thursday through Sunday, and we'll see what happens. All right.
Vamos a ver qué pasa, okay?
Okay.
Thank you. Thanks to both of you.
I have a question.
What?
Yo tengo una pregunta.
What?
Okay.
So right now, the time that we're waiting for Judge Hillary, does he still have to pick up the girls on Thursday, or do I have to wait for that?
¿Niños el jueves o solo tengo que ser yo?
I have an order out there, but it's the friend of the court won't enforce it as long as it's under appeal. Any prior orders are still in place. Thank you all very much.
Que las órdenes siguen vigentes.
Thank you.
Muchas gracias a todos.
You're on mute if you can. Ms. Emerson, can you hear me? Oh, Jesus.
Yes.
We just lost her now. Yeah, 35 of these and we're on number 2. We've had nothing but problems so far. We'll be here till Sunday. All of you can mute right now. I'm going to try and take one, and if we can take one right after that being you, that'll be great. Just mute yourself. Miss Emerson, I can't get you to connect.
7.
Well, let's see what technical problems we have here. Juan, can you hear me, sir?
Juan, ¿nos puede escuchar?
Correcto, sí.
Yes.
Thank you. This is the matter of Burgos versus Espinel. This is the prosecutor in this case for a judgment of paternity is represented by Mr. Hahn. This is a request for a judgment of paternity. Father does not dispute the paternity and does not want a DNA test. We will sign the judgment of paternity. There's also an order requesting support. It appears to be correctly calculated with mother's actual income and father's actual income. Sir, do you have any objection to the support order also?
Can you tell me what it is, and then I'll let you know.
You were sent a copy of it. Shows $748 a month.
I don't make that much money. She's lying to you.
Who's lying to you?
¿Quién? Señora Tamaya.
She didn't provide the information.
First thing I want to
Continúo.
tell you, the first thing I want to let you know, since I didn't know the laws, so well, we were living in Michigan, she was living with me, and she left the home taking my child out of Michigan.
That's not what we're here for. Your actual income was your 2023 gross annual earning. 64,724 that the prosecutor has been able to obtain, that was your gross income for last year.
$4.
All we're doing is entering an order of paternity and a child support order based on the incomes of the parties and the overnights.
Pero mira, yo tengo toda la muestra aquí, que si quieres se la envío al juez, desde que ella abandonó el hogar, que yo no he dejado de ayudar a mi hijo. Todas las muestras están aquí.
So I have all the proofs here that I can send to you that she left the home.
It doesn't matter.
De hecho, que
You don't even have legal rights with the child at this point unless you get a judgment of paternity.
She made me take him off the insurance at work because she's claimed that the laws in Michigan wouldn't allow him to be on my insurance.
Mr. Hahn, is there anything you wish to add? It appears that these are all not relevant to this case.
Yes, Your Honor.
Yes,
Thank
Your Honor.
you. A pre-hearing conference in this matter was scheduled for February 27th. Did call the defendant with the assistance of language line. The call went straight to voicemail, and the voicemail had not been set up, so we were unable to leave a voicemail.
I was working then, and I'm not allowed to have my phone at work.
Your Honor, I did wait for the defendant to return my phone call, but he did not return any calls to our office until March 13th. At that point in time, this hearing had already been scheduled, and our staff explained the same to the defendant. I do believe the documentation before you, Your Honor, is appropriate. As this is a UE case, Your Honor, I would like to note that all custody and parenting time language has been removed from the judgment, as I believe that is under the jurisdiction of Wisconsin at this time. I am requesting entry of this judgment in UCSO today. Thank you.
Is it your intent that we're going to collect the support and send it to Wisconsin?
Yes, Your Honor.
Sí,
All
señor.
right. All right. Well, I will find that he does not dispute the parentage, so it's in his best interest that we enter a judgment of paternity because now he can start to seek legal rights. Also,
Mire, ¿puedo decir algo?
Can I say something?
what? Let him interpret.
Okay. Thank you, Mr. Judge. I have always helped my child, and I have 4 children in total. And she always claimed that what I sent was not enough. But I live by myself. I have to pay my bills and the rent, and I'm supporting 3 other children.
Let's see. He's given credit for several other children. As a result, it appears that the child support order is correct based on the incomes. And I will enter the 2 orders once they are presented to me.
Yo voy a entrar.
What do you want to say? We got to move along.
In order to get this kind of income, I have to work overtime, and I don't always get overtime, so I'm not guaranteed the income.
Sir, this is based on your whole year last year, which is the best indication we have. So I'm going to enter the order. If you wish to try and modify it sometime later, you can try. But I'm going to enter the orders. And if you want to get some legal rights with your child, you're probably going to have to file in Wisconsin. Thank you. We are adjourned. I'll sign the orders when they are presented. Thank you.
Thank you, Your Honor.
Gracias, ya terminamos. Voy a firmar la orden cuando se me presentan. Gracias, señoría.
La orden me va a llegar aquí.
Parties are present with their respective attorneys being, hold on. Ms. Emerson, you're here on behalf of Mr. Bailey, I take it as attorney?
Yes.
All right, yeah, your client is here. We also have Mr. Hodel and his client together. This was a motion filed by the father to modify parenting time. I'm somewhat perplexed because the motion says that it gives me that 2 weeks that says parenting time for the plaintiff is set as follows: week 1, Wednesday to Friday, week 2, Wednesday to Monday. That gives him 7 out of 14 days. I'm not sure what you're asking for more parenting time.
Essentially, I don't think that's an accurate reflection of what the order is. It's truly a rotating schedule that changes every week. I think the language in the order, I can pull up the exact language, but
well, there's something in there about, is it a 4-week rotation, Mr. Podol, as opposed to a 2-week?
Yes, Your Honor. So it's the first 2 weeks, it's in a 2-week block. In the first 2 weeks, he gets 7 out of 14, but in the second 2 weeks, he gets 4 out of 14.
All right.
So they actually had it incorrect in the motion, and I didn't have a copy of that judgment at the time that we responded.
All right.
So currently it's 150. He has 150 overnights and he's 50-50.
He currently has 4 out of 14 and then 7 out of 14. So he's really missing 3 overnights is what you're saying.
That's correct.
Make it equal.
Yes.
All right. Says he's now a disabled pilot, has time and all this and wants 50-50. What is to prevent this from being a Vidvarka situation as opposed to shade, ma'am?
We believe that in this case, there's proper cause or change of circumstances is sufficient. Here,
Vidvarka or shade? Shade maybe, but not Vidvarka. What is the proper cause change of circumstances? I mean, I understand he doesn't work, he's on disability, but
well, she's had another child who's 1 year old. She's also moved to Portland, which is an hour away from my client now. My client has lost his, he isn't working anymore as a pilot, and the parenting time schedule that was entered was essentially based off of his work schedule because he had seniority at his prior job. So he would essentially be able to choose his parenting time. He's looking for some normalcy at this point because he isn't in that position anymore. So we believe her move along with the birth of her child. My client believes that.
does he have a child? Does he have a family now?
No.
He's not married or anything?
No.
All right. I mean, I don't find that her having a child creates proper cause of change of circumstance. There's nothing unusual about that, but all right. Mr. Hodel, what's your response?
Well, I would say I don't know that moving to where she moved is necessarily a change in circumstance either. It's not a long distance.
Where does the child go to school?
In Portland.
Oh,
No.
Or I'm sorry, Ada Christian School. So it's a midway point between the parties. And
No,
then
it's not.
additionally, my client would point out that at the time the parties entered the judgment of divorce was during COVID, and that Mr. Van Wynen had taken an extended period of time off of work, and in anticipation of that, his parenting time was incorporated into that as well. This, I don't want to get caught up in the minutia of this, but this seems like more of a child support issue than it does a parenting time issue, because the parenting time is pretty close right now.
It's pretty close, but if the child is going to be going to Ada, obviously, I think father lives closer to Ada Christian than mom does. Is she going to be able to do all that transportation, or are we going to fight with the school when the child, I don't know, it's young 5s now, but when the child starts to school, is that where he's going to continue to be enrolled?
My client is a stay-at-home mother, Your Honor. She is providing transportation for the child.
And intends to? I mean, all I'm trying to do is avoid something next year.
I understand that, Your Honor, but my client doesn't have any issues with the current parenting time order or providing transportation at this point.
All right. Ms. Emerson.
Yes, if I may interject, I think my client has concerns about her ability to care for their shared child with her new infant. The child about being stuck in the house all the time because she doesn't truly have the time to.
She's a stay-at-home mom. That's what I'm told.
And my client is receiving complaints from the minor child that she doesn't have the time to devote to both the new infant that she has and him. My client, he, not working as a pilot, he has the time now and he's willing to help her and provide additional assistance. He wants the minor to get involved in activities. He's growing, and my client has the time now, and he should be allowed additional time, equal parenting time. It's in the best interest of the child to have less exchanges and have some normalcy in their parenting time schedule.
Your Honor, I question the veracity of those statements regarding this child, given the child's age.
Well, I'm not going to listen to that because it's a 5-year-old child. I don't know what. And okay, my wife had 2 kids and they were young, and the older one had to do a little bit more when the young one's really young, and I just don't think that's any argument at all. worth anything. All right. I don't have anything that shows that, that the 5-year-old William is being neglected. So.
No, Your Honor.
No,
If anything, Your Honor, I would cite, you know, plaintiff's own admissions in here, which is that he suffers from chronic back pain, other issues to the extent that he's going disabled. He can't work. He's had heart failure. He's had a stroke. I question his ability, if anything, to care for a 5-year-old child on a full-time or, on any more of a basis than he's already doing. I don't know if that's true. I just kind of highlight that could be an issue. So.
All right. Well, I don't believe that Varka is met. And if they're asking for 3 extra overnights, I believe, probably it's right on the border between Vidvarka and Shade for that, but it would clearly affect an established custodial environment, although both probably have one. But to do this, I would have to have a hearing, and I don't believe that there's anything here that would have me have a hearing for proper cause or change of circumstance, at least as it relates to Vidvarka. It's, as I say, it's 3 extra overnights times 12. It's around 36 extra overnights a year. I've not been presented anything that really warrants that, other than I'm sure he wants more time. I don't see that the child is neglected or anything where the child is, so I'm going to respectfully deny the motion. Thank you all very much.
Thank you.
You'll draft the order, Mr. Podel?
Yes, Your Honor.
Thank you. We're adjourned. DC, matter of Coriano versus Stressman. When Mr. Stressman is in the courtroom, Ms. Coriano and her attorney, Mr. Lambert, are on Zoom. This is mother's request for additional parenting time, making statements about proper cause or change of circumstance. Mr. Lambert, there's no doubt that what you're seeking is not a change of parenting time. It would be a change of custody hearing. You're asking for a lot more time, and I can't do that without a Vidvarka. You understand that?
I do, Your Honor. I
All
did
right.
discuss that with my client.
I know you also have an objection to the friend of the court child support, and we'll set a hearing for that one. But as far as this goes, what is your proper cause or change of circumstance?
Your Honor, my client cites a number of issues that she has. Obviously, the first one would be with the Satanism.
Well, let me say that's not a change of circumstance, because the picture that I have is from 2019.
The other issue she has is the glorification of violence, the possession of a pistol and a tactical vest.
When is that picture from?
You asking me?
Well, I don't think Mr. Lambert will probably know.
So that picture was like 2023.
Like 2023?
Yeah.
And why didn't you do anything at that time?
In the beginning, so when I try to like come forward this time, I was trying to work with him instead of creating like a whole, like a whole big ordeal. And I thought that, we'd come together and, try our best to work with each other. But it was apparent from, the way that we were communicating that it wasn't, going to work that way. So,
all right. I understand. You got pictures of him holding a gun. You got pictures of him with smart whip. Objectifying women, you say, because there's a picture of a woman in there that I don't know anything about the circumstances about that. The fact that he takes a picture of some woman and posts it on his Facebook is like meaningless. The only thing that I find is anywhere near any kind of proper cause or change of circumstance, maybe the pending DWIL or DWI, because I'm not even sure that that's sufficient. Mr. Lambert, you got an uphill battle. I'm just warning you.
Yep, I'm aware of where we stand here, Your Honor. The other issue that she has is the communication between the parties. It's in paragraph 11. It's just horrendous. I don't even want to say it, and I will not say it. The profanity, the name calling, essentially denigrating her, telling her she has nothing to offer but her physical parts to the world.
I'm going to take a moment with Mr. Stressman on that. And I am, Mr. Stressman, you can say what you want about our family wizard, but I'm going to order that communication go through our family wizard.
Yes, sir.
Any communication like that, if they come back in, I'm gonna burn you if you do that kind of stuff. Do you have any question of what I'm saying? If you're not gonna treat this woman as the mother of your child and not treat her the way you want to be treated, don't look to have much time with your child.
That's right.
All right, that'll end that because I'm gonna order our family wizard.
We need to make sure that mom is not disparaged by third parties, that he's not disparaging mom, her parental authority, undermining her, alienating her with the minor child. The child is only 3 years old. The child has already learned to hit grandma, and his response is, boys will be boys. This is the concern about the type of man raising the child. Those are my client's concerns. She's worried about that. She would like co-parenting. She would like co-parenting therapy. She would like counseling and parenting classes, frankly. I mean, there is a lack of understanding here on what's appropriate for a child. I understand there might not be enough to change custody and maybe not even parenting time. I get that. But this kind of language, the drugs, the attempting to sell it, the
I'm
profanity.
with you on what you're saying on this. I told you you're gonna have a tough time with Vidvarka, but I understand. I'm gonna give Mr. Stressman just a moment, but I've already told him what's gonna happen with our family wizard and the way he's gonna communicate. There should be no disparagement, and I will allow you to put that in the order. It's almost impossible to enforce it, but it should be there. You don't have any problem with that, do you?
Oh, yeah.
He has no problem with that anyhow. Do the two of you want to take a co-parenting class? Miss Coriano says yes, sir.
Your Honor, if I may, I have documents of text messages to us where we did therapy and we did it and it didn't go the way she wanted it to go and she just ended the relationship. I have no problem going to therapy for my child, doing anything for my child. I just wanted to be noted on the record that we did therapy when because she didn't want to be with me and have a family, it all ended.
My question is, do you object to the two of you going to a co-parenting class?
No, Your Honor.
He has no objection, so you can put it in there. I don't know who you're gonna do it with, Mr. Lambert, but I would hope you would help this couple find a co-parenting counseling that they would go to.
Split the cost?
Split the costs.
All right.
Okay.
The other thing is I think parenting classes would be appropriate, Your Honor. The behavior is certainly not that which is in the minor child's best interest. If this continues, like I said, the child already feels comfortable striking his grandmother.
I don't know the circumstances of the grandmother, and I'm not, I mean, obviously it's not appropriate to strike the grandmother, but I don't know under what it is, how violent, what was done with it. That's kind of out there, and yeah, but I don't know what led up to it, what went afterwards, and I don't really want to get into that. I'm not inclined to order parenting classes for one party.
I've already attended parenting classes.
Do you want to go to parenting classes, sir, or not?
Do I have to?
I just asked you, do you want to go to parenting classes or not? Well, I'm gonna not order them at this time.
Sure.
But anything else that comes before me, because this is not the first time you guys have been here, okay? And if it comes before me again, and I have some questions about striking things like that, not treating. Okay, you've got to treat each other like you have respect for each other, even if you're not going to be together, no matter what. All right. And your language to her is not acceptable. And you've said you will change. This has got to calm down. Mr. Lambert, you can draft an order requiring our family wizard that the parties will attend co-parenting classes and no disparagement by either party. That's got to be mutual. Okay.
Yeah, no problem.
And we will leave it at that for right now. Anything further? I mean, you're agreeing to everything that I'm ordering. The other one, you object to the friend of the court ordering regarding child support. I guess I kind of have to have a hearing on that. We'll set up a real short evidentiary hearing on that matter.
That'll be fine.
There's really not, I gotta have a small evidentiary hearing if you object to the friend of the court recommendation. That's
all right. I'll prepare the order.
All right. We'll get in touch. Is there any time like you cannot be available for this short evidentiary hearing? You can be on Zoom too, but is there any time that you, all right. So we'll contact your office, Mr. Lambert, and set up a time. Okay.
There are times when I can't be available. I might as well let the court know now.
Well, I've got 39 motions, so Tracy isn't gonna be able to keep track of that. She will email you about it, okay? And you guys can work out a time.
That's fine.
Are you
Thank
going for the whole month of April or something?
Well, I'm going for 2 weeks at the end of May.
All right. Sure, we'll hopefully get, because it's only gonna be 1 hour at most, okay?
All right, no
And
problem.
So we'll see what we can do. My clerk will contact you via email. Make sure you get back to her, okay?
Excellent. Thank you, Your
Thank
Honor.
you,
Have a great
everyone. Take
weekend.
care. We're adjourned.
Thank you.
sir. Take
Have a
care.
great day.
Goodbye.
It's a communication device. You can look it up online and figure out what it is so that it's instead of texting and stuff like that, it's something that you will provide, and it's got all kinds of stuff on it, like a calendar that you have to fill in, you know, if the child has something on there.
Thank you, Adam.
If you will just look it up online, you should be able to figure out what our family wizard is, okay?
And I will be messaged about our next hearing for the child support order.
You will be given, yes, you will be given. Thank you.
Thank
Good
you, Your Honor.
morning. Thank you, Mr. Land. Let me get to my, gotta pick up the pace here. If I want to get home before dark. All right, Mr. Goodrich, are you there?
Yes, sir.
All right, put your camera on something beside the ceiling, please. We're here in the, we've got two cases, both filed by the prosecutor in this case, Ms. Rummel. She's present. We have both parties are present via Zoom. The petitioner in this case is the guardian for the children, and the defendant, in this case, Mr. Goodrich, is imputed with income. And there's been a request to enter an order. Ms. Rummel, anything you'd like to say?
No, Your Honor.
All right, you stand, Mr. Goodrich, anything? I mean, we're gonna enter a judgment of paternity because the paternity test came back 99.9999%. You're the father. Do you object to that?
No, sir.
All right, we'll enter that. What about the UCSO, the child support order?
Are you asking me, Your Honor?
No, I'm asking Mr. Goodrich if he objects, because I went through it and it appears to be appropriate based on the incomes and stuff like that. There are two children, Owen and Bryn Lee. It's based upon, based upon your income, which is it's imputed at $18 an hour for 38 hours. You have worked in the past, you have made that money, you've made more than that also at this point. What do you have to say about this, Mr. Goodrich?
You said I don't work right now. I DoorDash.
Oh, I mean, why don't you work?
I don't know why, because I do asphalt, so I'm waiting for the season, which is in 2 weeks.
So you'll be starting back in 2 weeks at that?
Yeah, it's either going to be asphalt or I get a year-round job, one of the two.
Okay, but you have been working at A1 Asphalt earning $18 an hour, correct?
That was last year, I think.
Well, but you said you're going back in 2 weeks.
Yeah, roughly 2 weeks. It all depends. When I heard the plants open back up the second week of April.
All right, so it appears that it'll be appropriate. The only question then is, when were you laid off from asphalt last year?
I stopped the beginning of January because I quit where I was working when I was cold patching.
You quit because of what?
I quit when I was cold patching.
So you could have continued to work at $18 an hour, but chose not to?
No.
Well, you just said you quit when you were cold
Yeah, he
patching.
quit, but then he shut down his business anyway, so he don't even have his business anymore.
As of when?
This year,
This year when?
I don't know when he shut it down.
Well, I'm
That's
trying to
the last
determine,
minute.
you've
That's
got to
what I
work,
heard.
all right? And you can earn $18 an hour or more. Even the Bureau of Statistics says you can make more than that. But the prosecutor's not holding you to more than that. You were clearly earning that amount of money back in October of last year. You were earning at least that much, $18 an hour, and you were working at least 40 hours a week. So I'm not, and you're gonna be going back to work, so it appears that the leaving there was voluntary. And that you're imputed at $18 an hour, earning that throughout the period of time because you were earning it from October on till January. You're gonna go back 1st of April, can earn that much or more. So I believe that the appropriate amount is listed by the prosecutor here. And the parent, if you will, the guardian's income does not come into play because they are a guardian. Anything else you want to say, sir?
Me, no.
All right. Anything from you, Ms. Rummel?
No, Your Honor, you've covered everything. Thank you.
Ma'am, anything you wish to say?
Nope, I'm all set. Thank you.
Thank you all very much. I'll enter the orders, sir. You will be now the official father of, I think it's Cody, or no, Owen, Braylon, whatever. You are now going to be the father and can do what you want with that. You'll be considered the legal father. When on presentation of the orders, I'll sign it. Thank you, everyone. We're adjourned. Yes.
Thank you.
Brown v. Gordon, both parties present with their respective attorneys. That is, Mr. Gordon is represented by Ms. Ballast, Ms. Brown by Ms. Wolfram. There were 2 motions filed in this case. The first one by Mom, the plaintiff, wanting a communication order, but it's my understanding in pleadings that were sent in by Mr. Gordon that they fully agree to that. Correct?
Yes, we're agreeing to use a communication app.
And is that the app that's we're doing is Our Family Wizard or what? Did you guys talk about what app you're going to use?
Our Family Wizard, yes.
Ms. Wolfram, that seems to take care of your motion.
Well, it takes care of my motion to the extent, Your Honor, that I had asked for the consent. I was told they had consented. I provided the draft. I have begged and pleaded for it to be entered.
It was in their pleadings that they agreed to it.
And they won't provide it to me. They won't send me the signed order.
The signed order of what?
The proposed communications order. I've not received it. And so here we are asking the court to enter it because they won't provide it.
Ms. Ballas,
Thank you. Yes, the order as presented had a couple issues which would have made it be rejected by the court. First, it did not have a de jure paragraph at the top. Second, it was labeled motion for.
That would be labeled order.
The caption said order, the header and footer said motion for communication order.
I'm not going to give attorneys fees unless you can't get that order entered within like a week.
I'll be happy to do it.
Yeah. All right. Then the next one is from the father, motion to modify parenting time and child support violations filed with the friend of the. If there are violations of parenting time, they must be filed with the friend of the court to resolve those first. But this is the one that I don't even understand how anybody entered an order that there's no parenting time order after summer of 2022. You get exact what they get and then it stops. What are you requesting from there?
Good morning, referee. The parties did work together to continue a parenting time schedule after.
There's no order to enforce.
And they did meet together and exchange the child for parenting time. My client is seeking makeup parenting time because there was no Christmas time. He showed up at the exchange place and he was denied parenting time. He did file a violation with friend of the court as requested. There's been no response from friend of the court on that violation.
I have no idea how they could violate her when there is no order that says he gets anything after September of after the summer of 2022. I mean, you can say they have all the agreements that they want, but the court can't enforce them just because then she says yes, he says no, there's that kind of stuff. There just isn't an order that goes past the summer of 2022 and we're at the summer of 2024. We can if you want to seek an order for parenting time, that's fine. I'd send you to mediation for that if you guys can't agree on it.
We did ask to modify the parenting time order because Mr. Gordon's father in Michigan is no longer able to allow overnights essentially, or in the near future will no longer be able to do that. I know the parties did communicate prior to this motion being filed with a potential settlement that both parties exchanged and had some ideas, but it didn't have a beginning date. It didn't provide for makeup parenting time to Mr. Gordon. I'm open to the idea of mediation.
All right, Ms. Wolfram.
Yeah, that's actually certainly what I've proposed since before Ms. Ballas was even hired. We've been asking to cooperate and develop a parenting time schedule. I even asked Ms. Ballas last night if we could do mediation and join, but she insisted on her client's behalf that he had to have the court order it. So yes, we'll agree to mediation, just like I said yesterday.
Mediation to be performed. I'll leave it up to the two of you to set up a mediator. But it has to be done soon, okay? Because either you're gonna reach an agreement or I'm gonna end up setting up some type of parenting time. He should be getting every other weekend, whether it is in Michigan or Ohio. That's the two of you figured it out before. And the exchange being in Auburn, Indiana, if I remember correctly. But you need to set it up. Can the two of you find a mediator to do it in the next 2 weeks? Mary Benedict can usually do it really quickly.
I can usually get in with Mary, and I do like to use her, so I'm happy to reach out and set that up.
Sounds good.
All right. If you can't get a mediated agreement, contact my office and I'll set up some type of quick time for you to get back in. I'll do a temporary order and we'll have some kind of hearing regarding parenting time then. All right. But I'm trusting that this has got to be taken care of through mediation. There's no reason we shouldn't continue the prior every other weekend and stuff like that, with at least half of it taking place in Ohio. That's what I'd certainly be looking at in a temporary order, just so you're on board where things are. But let's figure it out. I will order mediation, and with the understanding, if you can't get anything done in the next couple of weeks, call my office and we'll set up a quick kind of motion hearing that we can do on Zoom and talk about what kind of temporary order and other order we can do. All right.
Sounds good.
All right. I'll let somebody draft the order that we did there and submit it to me. Thank you all very much. Have a good.
I'd be happy to draft it. Thank you.
Thank you.
Okay.
Bye-bye. Smith. This is father's motion. Who is present in the courtroom. The defendant, or I think it's actually the plaintiff, is not present. How did you get a notice of this?
I sent certified mail on February 26th to the vast or the most current address that was in the court gave me.
That the front of the court gave you? Was it returned to you or anything?
I was sent a package that got returned to me from that address, but as far as the mailing address, it corresponded to the same. The most current that she has not filed.
All right. Well, if I'm not correct, wasn't the last time we were doing this, you were in Texas?
That's true.
And I ordered that you could have weekly video phone contact with your child. Looked like on a Wednesday or something like that at 7 o'clock. The biggest thing that I told you is I don't know how she's even going to know. All right. And I know you want to establish some kind of parenting time, and you've lost apparently contact with your child and have for quite some time, 7 years. And I believe you are entitled to start having some time, and you're, asking for it, but it's what I told you before, the practical. I don't, if you can find her, do you know where she is? Do you know where your kids are? I guess is what I'm saying.
I don't know where she is. I don't know where my kids are. I know that her parents live here in Grand Rapids, and child support is being taken out. So there's some no whereabouts of where she is, as she's getting the finance that I'm being able to provide for child support.
I guess what I would do if I were you at this point is file a with the front of the court each Wednesday when you don't get your time. Okay, you got to at least show to the front of the court that you're trying to do it on Wednesday and I'm going from memory, so this is not going to be good. But Wednesday at 7 or something, you get video or. Well, I mean, I have gone through this file lately, but and I'm an old man, so my suggestion to you is to show that Wednesday at 7, you're doing everything you can to do that. When you don't get it, file a violation with the friend of the court, because it is a court order that you get it, all right, and that she is denying it. They can issue an order to show cause to her for failing to follow the court order, all right, and maybe that will get her in here, because otherwise there's really nothing. I mean, I could say you get every other weekend, but I don't even know that that's right at this point, but you wouldn't know where to go pick up the kids. So that wouldn't do any good.
Would it be fair for me to be able to ask if parenting time could get reestablished even prior to, so that I won't need to file another motion to set up parenting time?
See, here, you can renotice this motion if you want at some time in the future for parenting, to establish parenting time, so that you don't have to pay the filing fee. But I'm not going to give you a time because you haven't seen your kids for 7 years. And I don't know what is going on with them. Okay. I mean, I'm only operating from the kids' best interest at this time. All right. So all I want you to do, and I may make a call to the friend of the court because they're obviously sending her the money and stuff like this. Okay. And see what they might do. But that's my suggestion. On a Wednesday, you don't get anything. You don't have any number to do that with. It's really her fault that you don't. Okay. And I'll see if we can maybe get her in on an order to show cause so you can start reestablishing some contact, or if she says, no, he's a horrible human being who, shot my kids and stuff like that, and he doesn't get parenting time, I'll deal with that at that time. But okay, so that's the only thing I can really tell you right now.
Also, step in the right direction. It might not be
How old is your oldest child? All right. And your youngest? All right. Well, let's see what we can do. I don't know, but I can't get anything if we can't find them. All right. So let's give that a try. Thank you. I'm sorry. Good luck.
I went upstairs.
Being late. You weren't late.
Yeah.
Trust me, you're not late. All right. Don't apologize. Save that for some other time when you really do need to apologize for something you did. Okay. This is both parties are present by Zoom. All right, Mr. Warren. It's a motion filed by the mother, the plaintiff in this case, for enforcement of the UCSO of 2019, because she says she has been for orthodontics for the party's child. Is that correct, ma'am?
It's for a doctor's bill. It's not orthodontics.
What is the doctor's bill related to?
I believe it was I took him to counseling because his dad and I had been fighting a lot, and I wanted him to have an outside source to help him deal with it. And at the time with the counselor, she told me that his insurance wasn't paying because they were denying that they were saying that mine was supposed to be primary medical insurance and it wasn't. His was. So he was supposed to call his insurance company and get it sorted out, and he never did. Yeah. Well, if he did, he didn't call the doctor's office and tell them that it was sorted out so they could rebuild the insurance. And this is where we're at now. It just never got paid, and I moved and stopped getting paid.
It was for counseling for your child. It was apparently necessary. Did you know the child was going to counseling?
Yes, I brought him to the appointments too. And like she's saying, I did call my insurance company and stuff and got it all situated at that time. And I never heard nothing back from her about this bill or anything. So I thought everything was good. And I called the office there at that time. And like I said, I haven't heard nothing back after I called my insurance and that office, because I even went to the office and talked to the people in the office to make sure that my insurance was first and Medicaid second. And it's always been that way since day one. I started at my job 13 years ago. So well, I don't know.
Obviously, there's still money owed. Did you send him a copy of the lawsuit or something so he knows, so he has proof of that, ma'am?
I did not, but I have a copy. I can give it to him.
Well, I mean, you got to know that you're being sued for something that is the counseling, and if it is because of the uniform child support order that you entered at the time you entered it, the last one was only for $18 for the medical. But it also stated that each party was responsible for 50% of the uninsured healthcare expenses. This would be an uninsured healthcare expense, and each party is responsible for 50% of it. I don't know what happened with your insurance and stuff like that. If you want to run it through and figure it out, I don't know if they will, because it's 5 years out, 4.5 years out. But unless it does, it appears that you would owe $690.61, sir.
Why should I get penalized for her getting sued and not giving me the bill like she's supposed to? And I know she's got plenty of the bills before this went to court, before she got served. So where is all the other bills prior to this? Because I know they send it to her saying, hey, if you don't pay this much, we're going to bring you to court. And she said she hasn't gave me nothing. So I'm not just going to have her money.
So what's the difference? If she sends you that it's a
because now I have to pay the court fees and everything included this amount.
What is
if that's correct?
Well, what's the court fee and stuff like that on it? I mean, they're asking for the cost of the bill. Are they charging you anything else?
Man. There's $122.36 listed for total costs of fees and other requested.
All right. That's not a very large amount, sir.
But why should I get penalized for her not giving me the, making sure that I get the bill if it came in her mail? That's a lot of money.
You're only responsible for half of that.
Yes, I'm not saying no, but if she got the bill before she got when she got threatened to go to court.
Was he notified of all the bills and stuff, ma'am?
No, sir. Shortly after he started going to that counseling, I had moved and didn't give the doctor's office my forwarding address. So I had stopped getting bills until I had been served.
Well, but you knew you owed some.
When I was getting the bills, I did. Yes. But when I was getting the bills, I was also nagging Daniel to call his insurance company and the doctor's office. Again, whether or not he did or didn't, I don't know, but I still am getting bills. And then once I moved, I stopped getting the bills, and quite honestly, it left my mind.
All right. Well, I want to get the bill paid. I think it's appropriate that it be paid. I don't know what happened. It sounds like your insurance company dropped the ball, sir.
Okay.
Well, I mean, it does. I don't know.
I understand. I called and got it all straightened out, and then I didn't hear nothing back. But like I'm saying,
you called who and got nothing back?
I called the insurance company and everything when this situation happened. And then I actually went down to the office because it's right in our town, and gave them, all the information that they needed from my insurance that my insurance told me to give them and everything, and told them. And then after that, I didn't hear nothing back from the office or from Deborah about this. So I figured it got all taken care of.
All right. And she moved and didn't get bills, and so she didn't.
And that's not my fault.
Don't care. I don't. You got to understand, from my standpoint, all I want to do is get the bill paid because it was for your child. All right.
Correct.
That's it. All right. And if there's an extra $60 because it had to be taken care of, I'm not going to make you responsible for anything more. If, ma'am, what's happening with this? Have you agreed to a judgment or what? Because he's only going to be responsible for $690.61. That's it. All
okay.
Right?
I'm not asking for him to be responsible for any of the interest or anything like that. I just want him to pay his half of the doctor's bill.
Send him a copy of the lawsuit and any stuff that's connected with it, or I don't know what I send it, give it to him.
I have an item. I have a paper with that. There's 4 different medical service charges on it with the amount that they charged.
When are you going to get it to him? Can you email it? Can you do whatever?
You can give it to me Sunday when I drop the son off.
All right. Give it.
Or I can take a picture of it right now and send it to him through text message.
Well, I don't care how you get it to him, but you will get it to him by Sunday. Sir, you're going to be responsible for $690.61.
Okay.
I'll make you pay her. I'm not saying you have $691 sitting aside right now. Okay.
No.
How long are you going to need to pay that?
Don't do 90 days.
That'll be within 90 days.
Yep.
And then that lawsuit, then from then on, ma'am, whatever you do with it, he's out of it. Okay.
I understand.
All right. So you will get him a copy of that. We'll do that. He will pay you $691.61 within 90 days. I'm going to make it as of 90 days from, what are we, the 22nd? From April. Yes. So you'll have April, May, June. It'll be due by July 1.
Okay.
All right. Good luck, everybody.
Thank you, sir.
Thank you.
Thank you. Both parties are present via Zoom. Mr. Krupp is present, representing the defendant who is with him. This is a request, 2 requests for child support and tax exemption relief, and also regarding parenting time. My understanding, Mr. Krupp, are you asking for less parenting time? Because right now he has alternate weekends, Friday at 8 till Monday at 8.
That order was never entered. I never copied it. But
I got it right here in the file. September 17, 2020, signed, sealed by me and Judge Hillary.
He never got a copy of that, Judge.
I don't know what to tell you about that, but I do know that he's got alternating weekends, Friday to Monday. You're asking for less time than that. He's got a midweek, Monday to Monday, 6 p.m. to Wednesday at 6 p.m. midweek. Holidays, these take precedent. Mother's Day, Father's Day with father.
Judge, we'd ask that our current motion be followed that parenting time schedule.
You asked what?
We'd ask that the motion we filed for parenting time be followed, not the old order.
So you want to reduce his time?
Yes, because of his work schedule, but what it does, it gives him 2 full weeks during the summer, et cetera, expands it a little bit, but it fits into his schedule a little better.
Your motion says he wants every other weekend, Friday to Sunday at 8. Ma'am, you all right with that? Because it gives him less than the current order.
I don't oppose to any of this. The only thing is that we did move up north and the kids go to bed at 8. Would there be possibility that it'd be from 6 p.m. to 6 p.m.?
Yes.
And I also see that he stated that he wants to meet halfway at Myers in Muskegon.
Yes.
That's not halfway for neither of the parties. I live up in Fremont, like 30-40 minutes north of Fremont, Michigan. So Grant would be the thing, but what we used to do is he would pick them up and I would pick them up after. So I don't know if we could still do where he picks them up and then I can pick them up at whatever location he
Judge, she lives in Hesperia.
has on there.
I know. She just said pick him up at the night. She will pick him up coming back. That's her proposal.
Well, that
as opposed to each of them going halfway, and it doesn't appear that the supermarket in Norton Shores or in Muskegon would be halfway.
He'll pick up on Maple Street, 86.
And then also
we
were doing every other holiday.
And she'll come to his address in Grand Rapids to pick up the
He will
child.
pick up, each party will be responsible to pick up the child for their parenting time.
Okay, at their residence. Okay, good.
At the residence.
Yep.
And you asked for 2 weeks, full weekends. It says summer parenting time to consist of alternating 2 full weekends. I'm assuming you're talking about weeks.
It should be 2 full weeks, Your Honor. That's a typo.
Non-consecutive.
Yes.
Ma'am, it's normally no problem that I would order something like that. But he'd have to give you notice of his 2 weeks by, say, May 1 of each year. And if they interfere with your weeks that you want, you would also get 2 full weeks if you want. But they only include any parenting time within that too. But he has to notify you of May 1. If you have other plans for that week, in odd number years, you get to choose. In even number years, he gets to choose. You understand that?
Okay. Yes, I understand. But I guess with that the only issue is that they have other siblings that they're very close to. So I mean, I know that they cry sometimes for their sibling.
So
I would, if possible, can we stick to that every other weekend?
what? No, he's going to get 2 weeks in the summer.
Can we? Okay.
That also
Okay,
it
okay,
includes
okay.
his parenting time weekend. It's 7 consecutive nights. He's got to be able to take the kid to for some type of vacation or something like that.
Judge, he hasn't seen the children since November. She's blocked them off on her phone and everything.
Well, why don't we finish this first? All right.
Okay.
So he'll get 2 non-consecutive weeks in the summer. He has to notify her by May 1. In odd number years, he gets the preference. In even number years, she does, in case there is some conflict with that time. All right.
Yep.
He's asking for half the Christmas break. That's a normal thing to do, ma'am. I don't know what you want with that.
I'm fine with that, but he's gonna keep them for Christmas. We were doing every other holiday, which he can take them, the first half of Christmas vacation. And can we stick to the every other holiday?
Yeah, the parties will exchange, and we'll have every.
Or do I keep them all holiday?
In other words, this year you'll have Christmas Day. Next year he'll have Christmas Day, but he also gets half of that break. All right. So,
yeah, that's fine.
So Christmas Day could be 3 days into the break, and he gets the first half. You'll still get Christmas Day, unless you guys can figure something out. But then you'll get him back to him, so he can get half of the number of days that are there. All right.
Yep, that's fine.
All right.
Taxes up, Judge.
What?
For the 2 kids.
Yeah.
She's an illegal, so she doesn't file taxes. She doesn't work.
Do you file taxes, ma'am?
Yes, I actually am currently married and I file jointly taxes.
And you are now responsible to file taxes, right?
Yes, sir. Yes, I have been. Yes.
She doesn't have a job, Judge.
I filed taxes for the past 4 years.
It would be reasonable to expect that you guys would trade. Well, what would normally happen is each of you would take one of the children as tax exemptions.
He has taken one this year, Judge.
Okay. How old are these kids?
7 and 12. And the 7-year-old doesn't even go to school. But we'll be filing a custody motion in a
That's
couple.
fine. That's fine. I'm not gonna deal with that now.
Yeah, that's not.
Bottom
before
line is that he can take the 12-year-old, she can take the 7-year-old, all right, for tax exemption. It's just, however, he does not get it unless he is current on his child support on 12/31 of that year.
He is current, you know.
I'm just telling you.
Yep.
That'll go in there.
Yep.
Sir?
Yes, ma'am.
May I speak?
Yes.
He actually up to date on child support, and
You're breaking up. I can't hear you now. What's going on?
I would actually want to end that because he has I'm saying, can you hear me now?
Yes.
Okay, I'm saying that he's never actually paid child support on time, and he's had hearings, and he has no show to any of those hearings. He actually had a hearing with you, and he was a no show, and he's always backed up. And if it's possible, can we stop the child support because it's too stressful on my behalf to have to keep dealing with this. And I can perfectly provide for my kids, and my 7-year-old is homeschooled due to they didn't have the programs that he needed in school, so he'll be going back to school next year. He's all caught up now.
She wants child support. We have no objections.
Ma'am,
I want to end child support if possible.
this is support for your children. It's not for you. You can take the money and put it into a college account if you want, but I'm not gonna force you. If you want it to go to zero, it's not a smart move, but I'll let you do it.
Well, then am I gonna keep dealing with the coming to the hearings because he doesn't pay his balance on time, and there's an owing balance on there.
Well, as of December 27, he owed $2,000. I don't know what happened since then.
So, I'm more than capable to provide for my children. They do sports, they do,
She wants to cancel support. We'll cancel support, Judge.
Well, this is also child support. It's not her support, if you will. Ma'am, why should I enter a zero child support? He only pays $127.
And he can't keep up with those payments, unfortunately. It's just too much. It's too much to deal with on my behalf.
All right. If you want to cancel it, we'll stop child support as of April 1 and make it a zero. That's what you want?
Does that change the tax exceptions?
Not really. I mean, the tax, he's got to take care of the kids when they're with him, but that isn't part of it. I'm not making it on that. You want
okay, well, I guess I guess we can keep the child support. I mean, it's only $127 for both kids.
All right.
So
child support stays.
I just don't want to keep going to hearings.
Your kids don't have to go to child support hearings. All you got to do is most of the time log in on Zoom, and if he doesn't, the court will enforce it. So
no, I do.
What do you mean you do? You're breaking up. You don't enforce.
I get mails that I have to get on Zoom calls.
Well, that's part of it. You
can hear me now?
That's the way it is. Yes. Child support will remain. Mr. Krupp, what else you want?
Her cell phone has been blocked. He's had no contact with her since November. She blocked him off on her cell phone, which is 278.
Whoa. We're on YouTube. Don't tell her phone number.
Can you have her unblock the cell phone so he can contact her in case of an emergency for visitation?
Ma'am, he has to have a way to contact you. I don't know what you want to do, but either unblock him or something because he has to be able to. What if there's an emergency when he's got the kids?
Yeah, that's perfectly fine. Can we use our Wizard Family app?
Why do you need that? That costs and everything.
I feel like he doesn't really comply with the things, and that's why we're in the situation that we're at now.
All I'm doing is he doesn't get a chance to text you because he wants to text you. It's only as it relates to the children.
Okay, that's fine.
So whatever that number is, unblock him so that he can contact you, Mr. Krupp. Inform your client that he's to have no contact except, as I've already said, regarding something important about the children.
Correct. Can we start parenting time next weekend on 3/29?
Yeah, he's supposed to be getting every other weekend.
Yep. I won't have the order done by then, but we should tell her it starts next week.
Ma'am, next weekend, starting Friday, he'll be there to pick up the child. All right? You're frozen again. You understand that?
Also,
Ma'am?
can you hear me now?
Yes?
Hello? Hello?
He'll be there next
Okay,
Friday. It
yeah,
starts
I
every other week.
understand that.
What?
Okay, also, I'm currently 27 weeks pregnant, and as he knows, we have 2 children together. I have high-risk pregnancies. So, I mean, there's times that I'm not going to be available to pick him up, pick the child, but my mother, my sister, somebody on my behalf will be there.
That's okay.
That's absolutely appropriate. All right.
Thank you, Judge. I'll prepare the order.
Okay.
All right, ma'am. Next weekend it starts. Good luck on your pregnancy. And we're done, okay?
Okay,
Thank you, Judge.
Thank you. We're adjourned. DM, good morning.
Good morning.
Jeswani versus Jeswani. Hope I got that right. Both parties are present via Zoom. Mr. Sullivan is present to represent the defendant. There's apparently 2 kids involved in this, a 15 and a 9-year-old, and this is father's motion for parenting time. It looks like the judgment of divorce in 2017 called for 50-50 parenting time, as it looks like, joint legal and physical. And it's kind of, is this right that it's kind of on a 2-2-5 schedule or something?
That's correct, Your Honor.
And one of the requests you say is for the summer to have week on, week off?
That's correct, Your Honor. With that type of a schedule, with the exception, there is 2 uninterrupted weeks that each of them would get. With the exception of that, neither party can go on any extended periods of time because every week is broken up.
Right.
So that's the
neither party can take the kids and go to up north for a week.
That's correct, Your Honor.
Ma'am, do you oppose that? Ms. McAllister?
Yes.
You do oppose it?
No, could you repeat the question, please?
They want to go to week on, week off in the summer once the kids get out of school so that both of you can do stuff with the kids for basically a week. Otherwise, you're always being interrupted one way or another. You can't go up to Mackinac for a week or something like that. And they just want to do a week on, week off. Is there any problem with that?
Right offhand, I would need to take a look and review my current schedule. I do have to let my employer know ahead of time what's going on. Personally, initially my request was to return to the initial schedule as the holiday parenting times initially aligned with the seasonal schedule. And during the summer, I'm not sure. I have many things that are up in the air right now and feel that I need more time in order to review.
Well, you've had time. The motion has been filed. I mean, I don't see any reason why you shouldn't do week on, week off in the summers. I quite frankly don't see why you guys don't do week on, week off all year long. It's easiest, but that's not the request today. It's just during the summer, during the school schedule for the summer.
Could be for the summer, Your Honor. Yes, on that request, yes.
So I don't see any reason why I shouldn't grant that. It doesn't change anything as far as a custodial environment, or there's no custody, there's nothing. Okay. So I'm inclined to grant that request, but then it goes back to the 2-2-5 or whatever during the school year. Ma'am?
I hear you.
Okay. All right. I
don't want to interrupt, Your Honor. We had made that same request or that same logic for the spring break. Right now, neither side can take the children for the entire spring break. It's the same 2-2-5 situation. We have asked that we would alternate spring breaks with my client getting even numbered years. Again, it doesn't change the number of overnights at all, Your Honor. It just affords them the ability to go someplace.
Ma'am, I'm going to order that, but I'll give you the option. Do you want this year's spring break or next year's, ma'am?
I will take next year's.
Okay. Then he can have spring break this year from the time kids are let out till just before the return to school. Next year, she gets the exact same thing, regardless of the other 2-2-5-5. Okay.
That would be correct, Your Honor. Your Honor, we also have asked in there for some specificity on the beginning and end of the holiday parenting times.
There is specificity for the end of it. It says 10 o'clock.
For the beginning of it.
Your Honor, with all due respect, I'd like to mention that that is the piece that I do not 100% agree with and feel that I need more time in reviewing. I do understand that with the age of the kids changing over the years, that it is time to re-review the schedule while maintaining that 50-50 split. However, my concern is that a more detailed schedule may offer clarity for one party and then also potentially put another party in a more restrictive position. Therefore, is why I requested additional time to review the detail to see how it would work.
It would just mean that the holidays would start at 9 o'clock in the morning and end. I think there's something in there that says it ends at 10 o'clock a.m. the following morning. That's what it says in the order right now. Mr. Sullivan, I'm sure
Your Honor, we would concur with that time period. We had set forth specific times which have been given to the plaintiff a long time ago. I sent this to her as well. We continue to hear that, well, I have to look at it. We don't move forward. We did, as attached to my motion, specify for each holiday very specific times, so there would be no question at all. We would certainly consider preferring to go to that, but I would leave that to the court's discretion.
Why doesn't all the holidays start at 9 o'clock in the morning and they actually go through till 10 o'clock in the morning the next day? That's what they agreed on in their judgment. They just didn't agree to a start time when I looked through the judgment.
Correct, Your Honor. 9 a.m. to 10 a.m. the following morning is fine.
So, ma'am, why are you, I mean, that's all it does. What do you want for a start time with these things?
That's what I'd like to review. Your Honor, my current work schedule is the challenge. We have to lock in a date ahead of time, as you know, before the schedule is published for work. And I want to be sure that I'm selecting a time that works for all parties, because in this current situation, I feel that for the sake of his family, with all due respect, that I'm kind of getting the short end of the stick here, having to change my entire work schedule, not only as well as my life.
What do you mean?
Because they want to go on vacation.
I don't even understand what you're getting at. I mean, do you work holidays?
Sometimes, yes.
Okay. So you can't exercise your time at that time? He's going to get his holidays, regardless of whether you're working or not. He's going to get every other holiday, and it's got to have a start time that's a reasonable start time. Otherwise, he doesn't get a holiday.
I'm not saying that I don't want him to have a holiday. I do want to exercise our rights on the holidays that we are to be with our children on any given year. However, my concern is that I have not reviewed the schedule due to a family emergency that took place. And I feel that I need the time in order to do that. And personally, today's hearing, I'm supposed to be at work right now. So,
okay, well, I'd imagine you have to be at work if we adjourned it also. So all I'm saying is the holidays are already set. All right. In your judgment, they're set in the judgment, and all he's asking, I'm not changing those holidays. I'm just telling you that the start time for holidays for you or for him is when the other person has the child, it's 9 o'clock in the morning. The return time is already in the judgment at 10 o'clock the next morning. If you want to,
what do I do if I'm supposed to be working during that time? I mean,
what you got to work?
Am I supposed to?
I mean, what are you going to tell me that the 4th of July starts at 9 and ends 10 o'clock the next morning every year? You know that's what it is. So why can't you work with work? You want to change it every year?
Your Honor, this is keeping me from having a full-time job.
No, it isn't. He gets a holiday. He gets the 4th of July. What do you want on the 4th of July? When it's his time. What is your time?
I do not have a full-time schedule, and my schedule changes because of my divorce situation, which is why I feel like I need more time to review the schedule, with all due respect to him and his newfound family.
2016, and this has been a schedule. You can work together with him anyhow.
And he also called me in January of 2018, asking if we could make a change and switch weekends. Therefore, we have not been following the exact schedule since then. And because of that, we have changed. It has caused more stress moving back and forth between the households on the kids. And what has happened right now is that the seasonal schedule does not align with the weekend, because that's what the court initially had done. And because this change has been made since January of 2018, we have not been following that weekend schedule to the T.
Nobody's going to interfere if you guys agree to something different, but there's got to be something there in writing. You do have 50-50. It is plain. He's going to have this spring break for a week, and then you're going to have next year's. You're going to do week on, week off in the summer. You can go to your employer and tell him that. You can understand that when he has his holiday time, that aren't the days in the judgment, Mr. Sullivan?
Currently, the children's birthdays are not in the judgment, and we do not have our birthdays in the judgment, as well as
Nobody's asking
Diwali.
for that. Nobody's asking what happens here. The holiday parenting time in the judgment. Odd years, the children shall be with the plaintiff on Easter as an overnight through Monday. 4th of July is no. It says everything right in here. I'm not changing anything of it. Children shall be with the plaintiff on Mother's Day and father on Father's Day. Holiday parenting time shall end at 10 a.m. All I'm doing is saying all that holiday time will start at 9 a.m. That's the start time. It's not changing anything. I really don't understand your objection. Mr. Sullivan, anything more you're asking for? Because that's what I'm ordering at this point.
Thank you, Your Honor. Just a little clarity, Your Honor. For the summer, my client would like the first week, which starts on June 7th, because the children get out of school. My client just confirmed on June 5th. And we would like those weeks to run from Friday to Friday, with the normal exchange time, which is 5 p.m.
Ma'am, what do you want for the exchange time? Week on, week off in the summer? Exchange Friday at 5, so that will be each Friday at 5. Do you have something wrong with that?
One moment. Mr. Sullivan, what I heard you say was to begin the first week of week on, week off, effective Friday, June 7th. Is that correct? At 5 p.m.?
June 7th at 5 p.m. That's correct.
And when does the summer end? Are we following school calendar,
Yes.
or should we set a specific date?
School calendar, because those things would vary too much otherwise.
They will go until, I'm assuming the kids, till the week when they start that, then we will go back onto the 225.
So what I hear you saying is the Friday before school starts?
Well, that'll be the last exchange of week on, week off. The Friday before school starts, that will be the last exchange, and you will then go back to 225. Correct, Mr. Sullivan?
That is correct, Your Honor.
All right, I've got a lot of motions, ma'am. Do you disagree with this or not?
I agree with the summer schedule, first week, June
right.
7th. And that's referencing the Friday to Friday at 5 p.m.
Yes.
With the summer schedule going back to 225 and pick up at Friday at 5 p.m. before school starts, which is typically Monday.
All right, I made my order on that spring break, as well as the start time for all holidays. I'm not going to change holidays at this point. Everything else is listed in the judgment. Is there anything else, Mr. Sullivan?
No, Your Honor. I will prepare that order and submit it to the court.
All right, ma'am, you're going to get it under what's called a 7-day order. You've got 7 days to object. If he does not put in the order, what I said is in the order. Good luck, everybody. Thank you. All right.
Thank you again, Your Honor.
Have a visitor in the courtroom. Royalty. And we have regular visitors on YouTube, including Cheryl and number 9. Cheryl and Missy and Carrie and regular viewers, Allison, holy smoke. Wait, hello, everybody. Hope you're having a great day. So far, it's going great for me. Number 9. You don't know that, but that is a Beatles. And every time I get a number 9,
every week when I get it, or every other week.
I sing some of the Beatles songs. All right, Miss Garber, where's Mr. Miller?
I don't know.
He's not here? Never logged in.
You have a Zoom.
There's a Zoom number. We're just going to check it. Garber versus Miller. The plaintiff mother is present. She has filed a custody motion. How did you get notice to Mr. Miller about this?
I gave him, yep, I certified mailed that letter to him at the most recent, can I have my wallet, Mom? I do have the receipt to that. To the most recent address that was already on file. I know last week on the 13th, he had a show cause hearing for non-payment of child support with that same address on it and was present.
Okay.
I have the receipt right here. I mailed it out the 29th of February.
All right, that's plenty of time. And it was sent, you say, to the same address. The last known.
Correct.
All right.
Yep, the last known address that was in file. Yep.
All right, this is a motion by the plaintiff, apparently has served the defendant appropriately. He is not here. It was originally scheduled for 8:30. We're at 11 o'clock, and he's never been on, to the best of your knowledge.
The Zoom user happens to be him.
Can you see the Zoom user on your camera? No, now you can't. Can you see who that is? Because he doesn't answer us. I'm assuming it's not Mr. Miller, but well, he's not there now. Can you tell if that's Mr. Miller? Ma'am?
I see that there's another Zoom user, but it doesn't say anything.
No, it doesn't. Can you see the person's face?
No, I cannot. I just see you, sir.
Well, that's too bad. Zoom user, what's your name? You're on mute.
Chauncey Washington, can you hear me?
Yes, what's your name?
Chauncey Washington.
Mr. Washington, we're gonna put you back in the waiting room for a minute. I'm trying to get to everybody as quick as I can. Thank you.
Oh, okay.
All right, ma'am. The only thing that's present in your file is a judgment of support from 6/14/17, which gives you physical custody.
There was nothing ever, under my knowledge, established in the custody in regards to him. I'm really just trying to establish custody, just to have some sort of legal paperwork to it. The last time that he did, in fact, see my son, it was just on agreed time, and he didn't want to give him back at that agreed time. So I'm just afraid.
All I'm telling you is you do have the order of 6/14/17 says mom has Jessica Garber shall have the physical custody of the minor child until further order of the court.
Oh, I guess you said what you said 6/14/17?
Yeah, that's the original judgment that was filed in this.
Oh, okay. I guess then, so what should be, he hasn't seen my son. He hasn't anything. I really just want to try to set some sort of parenting time up to establish something. So would you be able to recommend us to go to front of the court for that? Or I don't know.
Well, I can if you want. I mean, it's a strange request only because if he's not visiting at all, I don't know why you want to poke the bear.
It is. I know it is. It is a very, very strange request, sir. I've tried to ask him if he would go to mediation, and he just hasn't. And my son is getting to the age where he's now upset. Yeah, he's now upset and trying to. I'm just
a good father.
I'm trying.
I know you are. It's a futile thing to try and make somebody a good father. If he's not visiting his child, shame on him. But if you want me to, I don't normally do this, but if you want me to send it to the friend of the court to establish, see what they say about that, and also review child support, that's fine. Dad doesn't get any. He's $14,000 in arrears, it looks like.
Yeah.
But any overnights, his child support's not even $300 a month. We'll send it to the friend of the court for parenting time and for child support.
Thank you. I appreciate it.
I'm taking it that you don't have $150 to pay for your part of it, so I'm going to waive the fee. All right.
Thank you, sir.
To go to the front of the court. Okay?
Oh, I was not aware of that, but I appreciate that so much.
I'll waive it for both parties, and we'll send it for the friend of the court for parenting time and for child support. Good luck on
Review.
that. I mean, because it's probably likely that he won't show up for anything.
I was surprised when I called the friend of the court that he did show up last week to that hearing. So I was hopeful that he would then turn around a week and a half later to show up here.
Yeah, well, yeah, he's unlikely to show up, and unfortunately, you can tell Tyson that you can't make him a good father. It's up to him to be a good father. Good luck. You get stuff from the front of the court. Please respond to it appropriately. Okay?
I appreciate it. Thank you so much, Judge.
Good luck. Thank you.
Have a great day.
You too.
23.
That's me being kinder than 9DS. It is a matter of Neighbors versus Buxton. There's one child involved in this case.
Your Honor, she's going to try and log in on her phone. She's on a computer that apparently isn't working. If the court wants to move on to another, I have another one.
If you guys want to just mute and sit there for a minute, I'll take another case so that you don't have to all log back in. It'll be faster than.
That'd be great.
Sounds fine with me.
She just logged on.
Oh, she just logged on. Every time I say that, they log on. You might want to mute right now because we're getting feedback from you.
Yep.
All right, there we go. I already introduced the case. Ms. Neighbors is present with her attorney, Ms. Van Dyken. Ms. Walker is present with her client, Mr. Buxton. This is a motion filed by the father for custody, parenting time, and child support. I think to kind of short circuit this, there was a judgment of support entered in this case on 1/20/23, which gives initial custody to the plaintiff mother, but without prejudice to determination by the court, which in effect says if there's a custody motion, I basically have to have an evidentiary hearing regarding custody. I assume both attorneys agree with my assessment there, even if they don't, I'm going to say that, but.
Yes, we do. Oh, yes, I do, Your Honor.
So I don't really think there's no real reason to go through. I mean, dad claims he's a great dad, mom claims no, whatever. We don't even have to go through that because I got to have a custody here.
Correct.
Is there?
Correct.
And so is there anything, as far as child support, I know you want to go backdated and stuff like that. We'll do everything at one hearing.
Sounds good with me, Your Honor.
Ms. Van Dyken?
Well, Your Honor, I don't object to the court saying it's going to retroactively modify support.
I didn't say I'd retroactively. I said we can do all kinds of support.
Yeah, we can look at.
We'll look at parenting time, custody, physical, legal, yeah, child support. I know how I can retroactively modify and can't, okay? And all those issues. Do we need to do anything else? I mean, are the parties going to try mediation or something?
I'm happy to try mediation, Your Honor.
I'm happy to try mediation as well.
All right. Well,
Like,
everybody.
I'm sorry, Your Honor.
Oh, that's all right. No,
I was just going to ask Ms. Van Dyke if she had someone that she prefers to use or someone she's used in the past. If you want to shoot me some names, I do have a couple people that can do via Zoom as well in the Lansing area. So I guess you and I can discuss that as well too. Let's
include in the order that, that sets we're going to have an evidentiary hearing. The parties shall mediate prior to this, and that I don't care. If you can figure out who you want to mediate, put it in there if you want to. All right. That'd be great. Jesus, Pete, should have saved you guys to last because you're everything's going so good. Anything else I need to deal with?
Nothing.
All right. To both the parents, you'll get an order from your attorneys. They'll explain to you what I'm doing and what I have to do and that kind of stuff. And we'll see you. We will contact both Ms. Van Dyken and Ms. Walker for a date and time for a custody evidentiary hearing if you want. Do you want me to set it before you do mediation? I mean, you want me to set it in the next couple of weeks because it's going to be out a while then?
I think that's fine, Your Honor. I think mediation dockets for mediators and our dockets are probably just as packed. So I think if you set it out a bit, mediation could take place first.
We will, yeah. Ms. Dewey will be in touch with both of you. If you do mediate a settlement, please tell me right away so that we can take that hearing off, okay, for somebody else. Good luck, everybody. Thank you very much.
Thank you. Have a good day.
You too. 29. Oh, geez, oh, Pete. Miss Van Dyken's back. She never even left. Look up, and there she is again. Oh, okay. Sims v. Verbrugge. Both parties are present with their respective attorneys. Ms. Coletti representing the plaintiff, Ms. Van Dyken representing the defendant. This is a motion for legal custody and to modify parenting time, but the first issue really is legal custody filed by the plaintiff mother. Says dad hasn't exercised parenting time for a long time. They're into I believe, a disagreement on some medical issues that Mr. Verbrugge doesn't want some type of medication. She does. There's been, I face it, I know this case because I've been involved with it for years. All right. And both attorneys, I know that I've been involved with this thing for years. What do you briefly want to say, Ms. Coletti?
Well, I just, in addition to what's in my motion, I just want to address some of the allegations Mr. Verbrugge makes. He claims that he has parenting time, but he's been having parenting time only by FaceTime or at his parents' home when Ms. Bennett arranges it with his parents. Is
this part of your request to modify parenting time pending this evidentiary hearing on legal custody? Because if I'm going to have evidentiary hearing on legal custody, quite honestly, between the two of you, you've fought enough and there's been enough that I guess maybe I should have an evidentiary hearing. I'm not saying I'll modify it. I do think there's some Vadvarka, mom says he's not involved in appointments and things like that. And he's been kicked out of the school property apparently and this kind of stuff. I'm thinking that there's enough for legal custody only. I'm not saying I'll change it. I'm not saying if I do, who will get it. That's a double-edged sword. But I think I'll have an evidentiary hearing on legal custody. So then are you moving on to this next section that you want his parenting time limited at this point?
Yes, Your Honor, he has a Wednesday overnight that he's not been exercising, and because he's 30 minutes from school and the child has anxiety about being late to school and doesn't sleep well, we're asking to suspend the Wednesday, and we would either ask to have supervised by a relative or suspend his time. His parents have a good relationship with the child, and I believe they're willing to supervise. So if you don't order suspended parenting time, I would ask that his parenting time be spent at his parents' home.
Ms. Van Dyken, I have your response. I know he denies a lot of stuff. There's something odd in that denial, in that you say he's been exercising all his parenting time, but then when he was
attempting
February,
He's
what?
been attempting to. He drives the 30 minutes out to the house to get.
Has he filed anything with the
has
front of the
filed
court
that,
since
He has.
December through February?
He is waiting to hear back from the front
All
of the
right,
court.
we'll
Yes.
deal with that at that time.
And
All
the
right.
court cannot change
Don't.
time.
I
And,
can.
I need the court to state specifically why it's found the threshold to have an evidentiary hearing on legal
I just told you. I just did state
I
specifically
didn't hear what your reasoning was that they have met the threshold.
for having the hearing regarding this.
Correct.
The only thing I'm going to state is that I believe there is enough to have an evidentiary hearing about this, at which point that has to be proven as part of the proofs in order to get to the next step. All right. I only preliminarily find, because I'm not having an evidentiary hearing and I don't have evidence, if you will, sworn stuff to have it. I make my initial finding that there's enough that I will schedule it.
I just want to be clear. You're scheduling the hearing. They still have to meet threshold.
Everybody still has to meet threshold
Thank you.
when they are there. Okay. But I evaluate these things and decide if there's absolutely nothing, I don't give the party a hearing, and I'll say that. But it is not, that is part of any, if I have an opinion, I will start out with whether the parties met threshold or not and why. Understand?
Understood.
Ms. Coletti, you understand too?
I do. Thank you.
All right. As far as parenting time, I am not going to modify it at this time. However, because this is such a contentious, I intend to appoint a GAL in this case. All right. And I intend to appoint Stephanie Kirkstra as GAL. Both parties are going to be responsible to pay her retainer. I have spoken to her that she will take this case. All right. I don't know. She doesn't have any real knowledge of what the heck's going on, but she will agree to it. I guess she'll get an order up to me sometime. She is out of town right now, but you guys both know her, and she'll make contact with you and do whatever's appropriate. And I will appoint Ms. Kirkstra as a GAL. I believe she's going to require $1,500 as a retainer from each party. That has to be paid, and it has to be paid promptly. If I need to give a date, I'll give it 1 week from today. She will do her investigations. If something comes up regarding potential modification of parenting time, we'll deal with it at that time. You all know how guardian ad litems work. You all, I'm sure, are familiar with Ms. Kirkstra. Anything you wish to say regarding that? Ms. Van Dyken, do you object to Ms. Kirkstra?
I do not, Your Honor.
Ms. Coletti?
I do not, Your Honor, but I also refer to front of the court for a custody and parenting time evaluation, or just Ms. Kirkstra will do that?
Ms. Kirkstra is not going to do a custody parenting time evaluation. Ms. Kirkstra is going to do an appropriate guardian ad litem review and what is necessary. I'm not going to send it to the front of the court, because when I do, somebody will object to it and I'll have another hearing anyhow. It'll just be that I'll have a friend of the court. I've got 2 competent attorneys, and I'm sure you'll bring everything in front of me.
Very good.
So that's just as far as I'm concerned, that'll just push it farther down the road.
For clarification,
Pardon me?
clarification, parenting time remains as ordered, correct?
As ordered as of now.
My client will be picking up his
If Ms. Kirkstra feels something should be modified, she will let me know, and I'll call you in for an immediate hearing of some sort and make my determination at that time. We will have some type of an evidentiary hearing at that time.
Okay, and she's a GAL, not an LGAL, correct?
She's a GAL.
Thank you.
Any other questions? Somebody's going to draft this?
I will draft it.
All right. Ms. Van Dyken, agreed?
Yes.
Anything else?
Nope.
You're in time to start the basketball for the day. Good luck to both of you.
Thank you.
Versus for adjourners. Mr. Krupp is here representing Jeffrey Flowers. Mr. Crow is here representing plaintiff, Ms. Reed. This was a motion filed by the father objecting to the front of the court child support order.
Your Honor, I did have a procedural issue if the court perhaps could consider.
Fire away.
Yeah, I mean, and again, and please forgive me, I've been on this case for about a day now, so I don't, but from
I'll see if I forgive you or not. You'll have.
All right.
We'll see.
I was curious about the timeliness of this objection. It seemed based upon the register of action that the child support report and recommendation was February 16th, 2024. The objection itself was filed on March 12th, 2024. Now, by my count, but well, and I don't have a copy of the FOC rec. So if the FOC rec is a week hence, fine. But I have it at 25 days, and I just wanted to raise that issue with the court.
Judge, the notice had no 21-day notice. It usually does. It said the parties had to file their own objection. Usually the friendly court does. So
I don't know if it had a 21-day objection period on it or not. We can deal with that when I set it up for. I have to set an evidentiary hearing. That's fine. Although, you know, man, I looked through it and geez, oh, Pete's, Dad's pay stubs have been verified for 2023. And that kind of stuff.
I have a letter from his employer.
That's what I'm going to, what?
I have a letter from my client's employer.
Yeah, well, what are you going to do about the full amount that they said that they have that he earned in 2023, over $57,000? I don't care.
That's a mistake. I attached a letter to my motion.
I see the letter, but I don't know if it included, do you have his W-2? Do you have his filing for taxes? I mean, I don't care what the letter says because it says he earns X number of dollars. Maybe he's working overtime like crazy, and that's the amount in there. You'll be expected. We'll set up an evidentiary hearing, no more than 1 hour. You come in and you better provide W-2, tax returns, something like that.
Okay.
So, Your Honor, and forgive me if I'm being obtuse here. Just as it relates to
that's two forgivenesses in one day. You're never.
I'm asking a lot, referee. I understand that, but just as it relates to the issue at hand that I brought up just a moment ago, in that it appears as if the objection was filed late, and I'm not sure what counsel is indicating. This is a FOC recommendation. Is 21 days to object to it, and it appears
no notice of 21 days.
And it appears that the objection is outside of those ranges.
I don't know if it is because he says he didn't get any notice that he had to object in 21 days. I don't have it in here, and I don't know. You can bring it up at the time of the hearing but even if, quite honestly, Mr. Crow, even if it was outside of the 21 days and he starts saying, wait a minute, my income is half of what they have in there, I'm going to listen to it because friend of the child support, I just want to get the numbers right. All right. I mean, I really do.
Yes, sir.
And it may not be retroactive. He may have to pay it for a period of time until the motion is filed. I'll deal with all that. We don't need a long hearing. It should be 1 hour at the most. There's no objection to her income or whatnot, I'm assuming. So it's all going to be based on his, and I'm telling Mr. Krupp that if he doesn't provide a W-2 for 2023, his objection, W-2 and or his tax filings, because we won't have it until after tax day, he'd better bring a copy of his tax returns too.
Judge, I would check with my client, get a copy of his W-2. If there's a mistake on that part, I'll notify the court accordingly.
I didn't catch
We can address it at the evidentiary, Your Honor. Thank you.
What was that?
Judge, the plaintiff has a motion set for 4 or 5 on the same issue. That motion won't be heard. She filed it herself.
I don't even have it here. Do you know anything about it, Mr. Crow?
No, Your Honor, I don't as of yet. I'll speak with my client about perhaps consolidating it into this issue if that's what we're.
If there's something in there. All I want to do, I want the two of you to exchange financial information. All right, Mr. Krupp, that means W-2 tax filings. It won't be till after the 15th, so there's no reason both parties shouldn't have filed their taxes, and that should pretty much take care of a lot of this stuff. We'll be in touch with you and Mr. Crow to set up an appropriate time, probably 1 hour. All right.
Thank you, Judge. Have a good day.
You're forgiven.
Have a good day, Judge. Thank you.
13. We're cruising. Is this about the last one?
Yeah.
I've got a lot of them. All right. Both parties are present via Zoom. This is a simple request by Mr. Gray. Legal custody was not addressed in the order of 7/16/21. It was a judgment of support. It gave initial custody, physical custody, basically to mother without prejudice for either party's filing a request for the court to determine legal custody. I have to do it. Ms. Harden, anything you want to say? Unless you agree to give joint legal custody.
I don't agree to give joint legal custody.
What?
I don't agree to give joint legal custody.
All right. You know, you're going to have an evidentiary hearing then. You're going to have to bring in appropriate stuff. It's not something like this where we can sit and talk about it. I just have to have a hearing because legal custody has not been determined at this point.
Okay.
All right, Mr. Gray, you understand that? You're on mute, so. Hello?
Hello?
Hello? Did you hear what I said?
Can you hear me?
Yes, can you hear me?
Yeah, I can hear you.
All right, we'll send out a notice to both of you regarding an evidentiary hearing for legal custody. Best talk to an attorney or get an attorney in here. You'll be at a disadvantage to both of you, but we'll have an evidentiary hearing on it. You're gonna have to follow the rules of evidence and everything in introducing or doing whatever's necessary. Do you understand? We'll send out
Yes.
a notice. There's gonna be requirements on the notice. You're supposed to file a trial brief and exchange documents and all this kind of stuff. Please read your notice and be here at the date and time. We'll have it in person. Good luck, everybody. Thank you. Yes. Haight versus Colley. Mr. Colley, the defendant and moving party who has asked for custody, is present. How did you get notice of this to Miss Haight?
I walked out of the courthouse and dropped it off in a postal box down the street.
And that was done on what?
3 weeks from today.
All right. And it was addressed to her address, and you know that's her good address, I take it.
Yes, sir.
All right. She's not logged in at any time during this, so it appears that proof of service is valid. This is a custody motion by the defendant. Wants custody, says mom hasn't seen the child in a month. Avery is the child, as I understand it.
Yes, sir.
That apparently mom was contacted by CPS because son's been missing a lot of school, at least while living with her.
Can I make, I'm sorry, sir, to interrupt. Can I make a correction about that?
What?
After I filed the motion, I talked to the principal.
Yes.
They were not the ones that contacted CPS, so I don't know who contacted CPS, but other than that, everything I said is is right.
All right.
I just wanted you to know that.
Thank you very much. You believe that there's domestic violence in her home, is what you believe. How old is Avery, please?
Avery is 8 years old.
All right.
And she still to this day hasn't contacted him.
Okay. How long has that been?
She hasn't talked or any contact since before February 21st. After the CPS lady left my house, she went to Haley's house and I got a text message about 30 minutes later. She said, "Tell Avery I love you, love him with all my heart, but I'm done." And that was the last me or him have ever heard from her.
All right.
And yes, she was assaulted in front of my son by her boyfriend who was arrested.
All right, sir, I'm gonna have to explain something to you. First of all,
Yes, sir.
I believe that you have fulfilled the requirements in the case of Edvarka, which requires a proper cause or change of circumstance to schedule an evidentiary hearing regarding a change of custody. The circumstances that clearly have changed and do have a significant effect on your child's well-being is that she hasn't seen her child in a month. Nothing.
Right.
And that
There's
would be
nothing. Yeah, I'm
that would
sorry.
be a change of circumstance that would warrant me having an evidentiary hearing. I can't change custody on a Friday morning. I can only find enough to have an evidentiary hearing to see about changing custody. So we will set an evidentiary hearing for you for the purpose of changing custody. I don't know how I can stress to you enough, but it is going to be an evidentiary hearing where you got to follow the rules of evidence and, you know, anything you bring in or all that kind of stuff. If you're very much encouraged to get the assistance of an attorney because it is, you won't know much otherwise because you got to know an established custodial environment. You have to go through the best interest factors, things like that, stuff that most parents are not too familiar with. So I'm suggesting you get an attorney. You don't have to, but I'm suggesting we will have an evidentiary hearing regarding custody of Avery. My clerk will send out a notice to you. When you get it, make sure you read the notice because it will not only give you the date and time you got to be here, but it's going to tell you got to file certain things ahead of time, like if a trial brief and that kind of stuff. All right. So please make sure you read it. Okay.
Okay. Yeah, and also they're still taking money out of my paycheck and they're sending it to her.
All right. Are you behind?
And I'm working.
Hold on. Are you behind it all?
No, I've never missed
All
a
right,
payment.
all
I
right.
work full time. She has no job. She's never had a job.
Hold on. I understand. I will temporarily abate child support as of now. All right.
Thank you, sir. Thank you very much.
That doesn't mean it'll go forever, but you've got the child full time and I will let the friend of the court know that they should stop child support right now.
Thank you, sir. I appreciate that.
Anything else?
No, I guess not.
All right. Make sure you keep checking your mail because you're going to get that notice of an evidentiary hearing and make sure you do what is said. Okay. Good luck.
Okay, I'll do that.
Thank you.
All right. Have a good day, sir.
Thank you. This,
All right,
Ms. Lewis? Ms. Lewis, are you there? Can you hear me?
I'm here.
Mr. Jones, can you hear me?
Yeah.
You have video? That I can see you too? Present via Zoom, Lewis versus Jones. This is Dad's custody, parenting, and child support motion. There was a judgment of support just recently entered about a month ago. He gave initial custody without prejudice to the mother. There's no apparent established parenting time. Father is seeking joint legal and physical custody. What have you got to say, sir? What do you want to say?
Not sure how to get my camera turned back on. I just wanted to say that I am in my child's life. I want to continue to be in his life. I just don't want to be constrained to seeing him at his mom's home under her supervision.
Is the child one, ma'am?
Yes.
Right. He's going to start seeing the child not at your home, I can tell you that. He's seeking joint legal and physical custody. Do you oppose that?
I don't feel comfortable as of right now.
Oh, why?
Okay, 1 second. He has a bad temper, and it would have been a lot easier if his family was involved, but they're disrespectful as well. And so I tried my best to come to a common ground. Like I told him, every time we touched conversations on it, like he doesn't have a reply back. So it makes me feel like I'm not making the wrong choice. And then it's like, okay, well, have your family like reach out to me, like let's talk about, the situations that happen.
Dad, we don't have to have families. He's asking for time, and I got no reason to believe that he's going to harm the child if he has the child.
Okay.
I mean, you may have a bad temper. I got a bad temper sometimes too, but I didn't harm my kids. All right. And if he's going to harm a 1-year-old, then, sir, I don't even know how to tell you how much trouble you'd be in. But I'm assuming you aren't going to harm your child.
I would never.
All right. So what we're going to do now, either I got to have what kind of time are you seeking with him? I got to do some kind of temporary order, because if we're going to have an evidentiary hearing, I got to have some kind of a temporary order where he can see his child.
Okay.
What kind of time right now are you looking at, sir? Not 50-50. I'm not going to do it because the child lives there, and that would be a huge change of an established custodial environment, but I'm going to give you some parenting time.
Yeah, I mean, whatever I can get as of now. I haven't seen him in 2 months now, so whatever I can get. And I was going to request, my older brother just passed away yesterday, and I was going to request to come to my brother's memorial service.
When is that?
It hasn't even been planned yet, but we're aiming for next weekend. Hopefully. He just yesterday.
All right. Well, I mean, I don't know how much a 1-year-old needs to go to a funeral or something like that. I'm going to give you some time. Ma'am, is there any way? It's kind of hard. It's kind of hard to hear. Why don't you mute for a minute, ma'am, because the child's making a lot of noise. All right. Thank you. Mr. Jones, do you work or something? Oh, goodbye, Mr. Jones. He just vanished. Ma'am, it's probably my intent to give him every other weekend from Saturday morning to Sunday evening, and give him one evening a week until we can figure this thing out, like a Wednesday from, I don't know, 4 o'clock till 7 o'clock. But
okay, every other weekend from Saturday night to
Saturday morning till Sunday night.
Saturday morning to Sunday night, and then you said one day out of the week?
Probably. I'm trying to get from, all right, he just logged in. Mr. Jones, can you hear me?
Yes.
Do you have a work schedule or something?
Yes, I do. I work Thursday through Friday, 11 a.m. to 9 p.m.
All right, so it's not really practical during the week that what from 11 a.m. to 9 p.m.
Yes, my schedule can be altered though.
Well, I'd like to see you see your child kind of regular. I'll give you like one, ma'am, does it work if you tell me a time every Wednesday that you can meet for a while? I would normally give you from like 4 o'clock till 7 o'clock every Wednesday, but that doesn't work with your work schedule. What does, sir? I'm going to give you every other weekend, Saturday morning through Sunday night also.
Okay. Okay. What about mornings through the week? And can it be an early time in the morning?
Well, I don't know how, I mean, I don't want the child to have to get up at 4:30 in the morning to do something.
Maybe not 4:30. What about maybe 7 a.m.?
What about 8 o'clock till, what time do you leave for work?
Right about
9:30.
What time?
You don't wake up until 9:30.
Well, then, okay, he can have, what time do you leave for work? Then I'm going to give him a lot more days.
Maybe 10:30.
All right. Well, I think you can get your child up at 9 o'clock and have Mr. Jones have Tuesday and Thursdays. He can have 9 o'clock till 10:30. I just want to have him have time with him. He's got to develop a bond. Okay. And the more frequent you see him, so you could have Tuesday and Thursday from 9 o'clock till 10:30. Can you do that, sir?
Yeah, yes, I can do that. And that's another thing. Like we have a bond. Like it's not like
I know, but you said you haven't seen him in a couple months. All right. These are
Right.
little kids, and the more you get with them, the better. All right.
Right.
And then we'll give you every other weekend, Saturday we'll make it 9:30 to Sunday at 6 o'clock. Does that work?
Yeah, that's fine.
This is all just temporary anyhow. All right.
Okay.
I just want to have you have time, and you'll be able to take your child wherever you want.
Yeah. Thank you.
Well, you're welcome. I think the two of you ought to talk about, we got to set up a hearing to establish custody because it's not in the order. Custody, parenting time, child support. We're going to set child support for the guidelines. I'm going to refer this matter to the friend of the court for child support. Okay.
Okay.
And the two of you kind of should talk about this and determine what you can do. Ma'am, I understand your concern because whatever your concerns are, but he's the dad and he's going to be given a chance to be the dad. All right. And if you guys can come up with something, what you agree on, call my clerk and tell her, and we'll put it in a court order and you guys can sign it. Okay. I mean, if you can figure something out, but he's got a dad and he's got a mom, and both of them got to be in the child's life. Until then, we'll have the temporary order. You'll also get a order setting a evidentiary hearing. It's going to give you requirements that you have to file before that. The best thing you could both do is hire an attorney if you're going to fight this, because you don't know what you're doing in court. You don't know what it is to do, follow the rules of evidence and stuff. So I'm suggesting you go find a good family law attorney, but we'll send it out to you and we'll expect to hear sometime later. In the meantime, we'll get an order out. Mr. Jones, you can start your parenting time next weekend. You can start it this Tuesday. Okay. 9 till 10:30. And then again Thursday, and then next Saturday, and then all right. So it will start with Tuesday today. Your weekends will start next week. Any questions?
Okay, so I want to write that down real quick. So Tuesday
9 o'clock to 10:30. I got a lot of cases here. Tuesday and Thursday, 9 o'clock to 10:30. Saturday, 9:30 till Sunday at 6.
9:30
In
a.m.
order also, we'll send it out to you in an order.
All right, thank you.
Good luck. Thank you, ma'am. Do you have any questions? You can shake your head no, or what? What?
No, I think I got it.
Good luck, everybody. Thank you. Have a good day.
You too.
We're adjourned. Hope you brought your lunch, or else you're planning on going to lunch soon, because no, if she leaves, I'm leaving. If you leave, I'm leaving. It's that simple. It's a motion filed by the plaintiff mother regarding child support. Ma'am, I hate to tell you, but this case that you filed has been, it's been dismissed. There's nothing for you to file under.
I know.
Asking for child support, but there's a motion there on June 17 of 2015. It says it is ordered that the complaint is dismissed without prejudice effective upon payment of arrearages. There is no case here, so you'll have to figure out how to establish a case or do something for child support, but he can't do it under this because this case has been dismissed. Has been for 9 years.
Yes.
All right. Sorry.
Yeah.
Good luck. If you can talk to a family law attorney or something if you need it, and maybe you can figure out how to file for child support. But this case has been dismissed. All right.
All right.
Thank you.
Thank you.
Both parties are present by Zoom. This is a motion filed by the father objecting to the friend of the court order regarding child support. Sir, I mean, your objection says, how can it go up 200%? I'm not a magician and don't understand it. Don't know. I do understand it, but I've contacted the friend of the court. They sent me all the documentation regarding it. Basically it shows they checked for your income from January 17 of 2022 through October of 2023. They also did hers for that kind of time, plugged in the numbers, the number of overnights and everything like that. And you were given an adjustment for some insurance. It's a correct number.
The thing is from January 22 to 2023, those 2 years, I grossed $91,000 total. And the previous 2 years, from 2020 to 2021, I grossed $80,000 total. So basically, I made an extra $5,000 a year the last 2 years from the previous 2 years. So there wasn't much of a difference in my income. And they had me paying $115 a week for 2 children.
Point out where you gotta point out in there where the calculation is wrong. They put it into the computer, it spits out the number, and the calculations show that they're checking your income, whatever it is, and they provided all of that to me. I don't know why. Maybe you were wrong in the money you were paying before. Maybe it was way too.
I didn't set up what I was supposed to pay when I first started paying child support in 2020. They had me paying $115 for 2 kids. I mean, that was their decision.
Tell me what
I didn't make that.
The objection is you don't want to pay that much. That's not an objection.
But I don't understand how I can pay $115 for 2 kids and now all of a sudden I'm paying $162 for 1 when
That's what your income shows.
But my income hasn't changed.
Maybe the calculation before was wrong. I don't know, but I've checked through the calculations and it appears to be correct. There's nothing in there. They looked at your your income and made that determination. They looked at hers. They looked at your credit for insurance. They have gone through everything that's there, the number of overnights. It appears to be correct. There's nothing other than you saying, I can't believe I'm paying more, but that doesn't provide me anything to show that the calculations are incorrect.
Well, how did they come up with the calculations when they started this whole thing?
Put it in the computer. I don't know. I wasn't there. Ma'am, do you have anything you want to add?
No, but he's not even taking his kid right now, so it should even be more than that. I have him full time now. He doesn't even pick up his child for his parenting time.
Well, he's given credit for 54 overnights right now.
Well, he's only had him 3 times, 3 weekends since September of last year.
If you want to, file for a child support review, I don't know. You'd have to file something before I'd even consider it. All I know is
as far as the arrears go, I didn't realize that I was like $1,400 behind payments. That completely shocked me. I've been having it taken out of my check, except for there were some times where I switched jobs a couple times and there was some lag time, but I personally made about $1,300 of payments directly to her Lake Michigan Credit Union account, and I'm not sure if I got credited for that.
Probably not. If you made it directly there, did he?
Well, I did. I did put
to you,
the
ma'am? Direct?
I did put the paperwork of the proof of those payments. Do you have that?
I'm not working on arrears because even if you sent that in, I have no way, unless she says yes, that was in there and not given credit. She could say that was for something else other than child support. I don't have any idea. Ma'am, did he make
I
direct
labeled
payments
it
to you?
under,
Sir, hold on. Did he make direct payments to you?
Not that I remember, no. I don't remember.
I have proof through my bank that I just made copies and when I did this objection, I made copies of it. You don't have that copy of all those transactions?
Again, if she says it's not there, then.
But it's in, it's proof. I have proof through my credit union, this transactions that I copied out.
Do you have that proof or not?
I don't have any proof. No, I don't have any proof.
Contact friend of the court, send it to them and see if they give you credit or not. Send it to the friend of the court. Say, I'm not 1,400 in arrears because I sent this direct to her. They'll do
I
it.
did.
And if they choose not to, that's the friend of the court. Good luck. I got to deny your motion because there's no substance to it at this point. Thank you.
But I have proof through the bank that I made those personal. Seriously, Jill? You're saying you deny me giving you personal transactions from my Lake Michigan credit union account to yours? That's what you're doing?
She's also saying that I should review child support because you don't have 54 overnights anymore. I'm not doing that either. The two of you can work that out. If you need to contact a friend of the court to do it and see what happens, ma'am, if he gave you direct payments and I find out at some point through the friend of the court that he did and you're denying it, that's not going to go good for you. What's fair?
I didn't say I was denying it. I said, I don't remember. I would have to look back on my statements. I don't know as of right this second. I don't remember.
That's fine. You don't have to.
Okay.
I've denied the child support objection. Good luck, everybody. We're adjourned.
Thank you.
A heavy stress ball here. She doesn't know. My wife gave it to me and she holds it up when I've thrown it only once, I think. It's been a long morning and I'm still going. So both of you can hear me, I take it.
Yes, sir.
Quacklear versus Quacklear, a case that I'm very familiar with. This is the defendant. Oh, both parties are present via Zoom. Ms. Goller is present for Ms. Quacklear. Is Mr. Smith not representing you on this at this point?
No, he is not, Your Honor.
All right. This is the mother's defendant's motion for legal custody. They're at a point here now where I know that there's medical disputes going on. Specifically, the latest one that I know of is meds being requested by the pediatric doctor for Everett for anxiety. Father disputes that. It'd be up to me to hear it. We've had disputes in the past. There's been all kinds of disputes in this case for a long time. I thought for a while maybe parties get along, but there is clearly some problems. Mother says dad is regularly given notice of doctor's appointments, but never shows up. I don't know if he disputes that he was given those or whatnot. In essence, what defendant is asking for is an evidentiary hearing to determine whether legal custody should remain joint. And Ms. Kohler, I'm not trying to short circuit everything you said, but I've read everything, so, and I know this case. So, Mr. Quacklear, is there anything you wish to say? I'm inclined to have a hearing to determine whether or not we should continue a joint legal custody. That means just that. I would have a hearing. I'm not changing anything today because I can't. I would have a hearing on it and we'd make a determination whether mother would get would get legal custody. I mean, quite frankly, you could get it if the testimony came out, whatever. But the parties do frequently disagree on items back. I mean, I know there was COVID. We started out with that and came really close to have an evidentiary hearing on that. It was the last minute sort of thing. Anything you want to say about it, sir? I'm inclined to have an evidentiary hearing regarding legal custody.
I just kind of want to, apologize for, taking up your time, because this has been brought up, a couple times beforehand about legal custody, and the fact of me not showing up to, doctor's appointments and not being physically involved is kind of just, it's really not, not so much true in a physical sense. I'm working full time, Monday through Friday, doing my part to provide, financially for the family. I'm still very much heavily involved in keeping up with the children's schooling, keeping up with hospital or medical, doctor's appointments. I have access to all that. And
here's part of the problem is that you guys frequently can't agree on stuff, and then it comes to me. Just like the COVID vaccine, you guys couldn't agree on it, so I had to set a hearing. I know you settled it beforehand, and now, I mean, quite frankly, I don't want the court, me specifically, to have to decide every medical issue that comes up because you guys can't agree on it at some point. If I have an evidentiary hearing regarding legal custody, like I say, in theory, I could give you legal custody, and there's nothing out there that says I couldn't. I could give her, I could decline to change matter of joint legal custody. The fact of the matter is, if you guys are not going to get along for these things, and you don't get along, then I'm going to decide who should probably have and make those type of decisions. I'm not saying right now who's going to win. Ms. Kohler, you know that I'm going to have to hear evidence to make a determination who, if anybody, gets sole legal custody, and it may not change. I don't know. But I'm inclined right now to say that there is enough regarding now the latest issue being Everett's anxiety medication. I take it you don't want him to get that. Is that correct, Mr. Quacklar?
That is correct.
Right.
It was solely just as an option. It wasn't even a recommendation. It was kind of just put in as a trial run, and we've had issues with.
Why didn't you allow the trial run? Maybe it would help.
I believe it's a medication that isn't truly needed for his anxiety. I don't believe it's at the level that needs to be regulated, by meds.
All right, but again, disagreement. So I've got to make that decision.
Right. Well, it's kind of frustrating to me, Your Honor, that I am still heavily well versed on what's going on, both schooling and medication wise and whatnot.
I'm not saying you're not. This is not an indictment of you. It's just an indictment of the fact that you guys can't agree on some of the things that go on for the kids, and then you got to come to the court and make the court make a decision whether or not your kids should be involved in a trial run of this or that. And most of the time, it's certainly going to be based on the doctor, because I'm no doctor. Right. And you guys, if you can't work it out, then I got to make the decision, and it's happening too often. So I'm going to set a hearing for legal custody. You know well enough to know that you better have an attorney for that, because it's legally admissible evidence. Ms. Goller clearly knows what she's doing and that kind of stuff. And I hate to say it, but I don't think you do when it comes to rules of evidence and what is necessary. So, Ms. Goller, I find that there is enough proper cause or change of circumstance to have an evidentiary hearing. At that evidentiary hearing, part of your proof has to be whether there is proper cause or change of circumstance, because I'm just finding preliminarily. It's not through evidence that I'm finding proper cause or change of circumstance. I'm just finding enough so that I set on the court's docket an evidentiary hearing. All right. Ms. Goller, you are incredibly silent. Can I hear your voice even?
Yeah, you can hear my voice, can't you?
All right. Yes.
Yeah, but I mean, you started the questioning with Mr. Quackler, so I've been sitting here trying to be quiet.
It's been a long day. Okay.
I know. I can appreciate that, Your Honor.
No, I appreciate it. We'll set up an evidentiary hearing. We will contact you. Do you have any time, Mr. Quackler, that you're clearly, you're out of town for the month of May or what, that we can't set something for?
No, I will. I'll make anything work. I work Monday through Friday, full time during the day, but whatever time is set,
so do I, and I don't work at night, so I'm not going to set up a night hearing. I can tell you that.
I appreciate that.
We'll give you sufficient notice so you'll be able to work with your work. We will contact you, Ms. Goller, to make sure it fits in with your schedule. You don't have anything else pending at that time.
I appreciate that, Your Honor. Could I just indulge the court? We do not have a physical address for Mr. Quackler, so the only thing I could do was email that that motion to him. But I would like to at least be able to mail things to him rather than scanning voluminous documents. So if he could give us, and I know that there's been discussion between the parties, and my client has asked him for his address, but apparently he now lives up in Gaylord, which only complicates things further. But if he could give us his address today so that I can
can't
use
ask
that.
him right now because we're on YouTube and there's millions of us watching at this time, and I'm not going to give his address to the millions of viewers. All right, maybe there's 4, but I don't know who we are. However, Mr. Quackelar, you are to, today, you are to email your address to Ms. Goller.
Yes, Your Honor.
All right, you will.
Thank you very much, Your Honor.
Get that to her today so that, because she's going to have documents and stuff that she's going to introduce and whatnot into this, and she's got to comply with the requirements, and I'm not going to make her comply with the requirements if you don't give her that address. You will, I'm getting you on the record right now, you will get her your physical address by the end of today, correct?
Yes, Your Honor. I have no problem with that.
All right, that should take care of that. We'll set up an evidentiary hearing. I don't really think there's much of an order other than us setting up the evidentiary hearing, unless you want to do an order that he's to get you the address by
Sure.
today. If he
I'll
gets,
go ahead and prepare an order for you, Your Honor.
right,
And now
thank
that
you.
I'll have his address, I'll be able to send it to him.
Thank you, everybody. Have a good day. Enjoy the
Thank
sunny
you.
weather.
Thank you so much, Your
I heard
Honor.
it's like 70 degrees out. So
Sure, it is. Uh-huh.
thank
All
you.
right, thank you.
Thanks.
We've got our guest leaving.
Great. Yeah.
You're fast and efficient.
No, did she say I was fat?
I think she did. Give me that.
All
Then I'll
right.
give
Take
it
care. Have a good day. Thank you.
34.
Are we anywhere near? Oh, Jesus. Ma'am, you're on mute if you can. Do you think we'll be done at 12:30? No?
Okay, yes, I can hear you.
All right, we're here in case matter Tyler versus Washington. Both parties are present via Zoom. This is a motion that has been filed by the father. There was a judgment of support in 2014 that gave custody to the mother. Father was apparently, there's some abatement orders in there for him being incarcerated last year. Just says he's a good dad and involved and wants to, say he wants 50-50 time. There's no parenting time order at this point that I can find. Is that correct, ma'am?
Yeah, we never established one.
All right. Then, sir, what are you seeking?
That the schedule go back to what it used to be, because we had a schedule, but it wasn't.
There's no court ordered schedule.
Right. I'm talking about between me and her, because we never had a court order schedule. So me and her had a regular schedule that I give my daughter. I had her from week on, week off.
Well, you don't have her now, and I don't know when was the last time you had her.
I just had her last weekend.
Okay, so you get a weekend?
Yeah, I get her every weekend. Well, every other weekend.
Ma'am, is
But
that
I'm
what you
asking.
get?
Yeah, I guess when she wants to go.
Well, she's 11. You're still the mother. All right, you can't.
Yeah, I mean, like, in the sense, like, sometimes she has plans. Like, for instance, he called and wanted to take her to a father-daughter dance, but she wanted to go to a birthday party instead. Like, that's what I mean.
That stuff kids and parents have to work out.
Yeah,
Right.
that's what I'm saying. Like, when she wants to go, that's what I mean by that.
So why shouldn't I just give him an order for every other weekend from Friday till Sunday?
Why should you or why shouldn't you?
All right, either one.
Just because I feel like the commute would be too much for her it's too much of an adjustment as far as her staying over there during the week.
I said the weekend, every Friday through Sunday.
Oh, that's fine with me. He doesn't agree with that.
Well, so let me tell you this. Mother has the custody per order. You have to show Vedvarka to change custody. Vedvarka says the proper cause or change of circumstance. You saying that I'm a good dad who wants stuff all the time that doesn't fulfill Vedvarka to even have a custody hearing. I don't have a problem with you getting a parenting time order, such as every other weekend and that kind of stuff, but you don't qualify to modify a custodial environment and stuff like that just because you want it. That's not what the court allows. It's not what the law allows if you check the law.
Yeah, I checked the law. I had custody of my other kids. So where do it feel that you don't fit, that I can't take care of my kid. I get her to school.
I didn't say you couldn't
her-
take care of, I didn't say you couldn't take care of your
You
kids.
just said that was unfit.
I never said you're unfit. I said you don't fit Vedvarka. Vedvarka is a case law that says you have to have proper cause or change of circumstance to change custody from mom. There is nothing that you have pled that shows that. So I can't change custody.
So what do I have to show proof that I fit Varka? That's what you call it?
It's a case, Vedvarka versus Grassmeyer. 259 Mishap 499. It's a 2004 case that I have to follow. And every case is different. I don't know what is about your other kids it doesn't make anything. It's something you have to follow to change custody. And you don't meet that so that I don't have a custody hearing. Again, I think it's appropriate that you get some parenting time because right now you don't have any enforceable parenting time. And you never have because if you guys were just agreeing before, you don't have an enforceable parenting time. So I have no problem with, at least at this point, giving you every other weekend from Friday at 5 o'clock till Sunday at 5 o'clock. And that's the time you'll get right now. So you can see her for sure. I don't know when was the last time you saw her.
I've been doing that though.
He doesn't there's not an issue with him seeing her. I don't withhold her from him. She can go with him anytime. He just has a problem with her coming on the weekends. He wants her to come during the week.
I want more time with my kid. That's what I'm asking for. More time with my child. That's what I'm asking for.
You're asking for 50-50 and you don't meet the standard that I have to have an evidentiary hearing for. I don't know what else I can say. I'm not making this up. And as far as any individual kid, I'm not trying to keep you from them, but you don't meet the standard to have a hearing to get 50-50, which is what you're asking for. So I guess the best thing is you've asked for a change of custody. And I am saying it is denied because you don't meet the Vedvarka standard. And nobody wants to do a parenting time order. So if you want a parenting time order, somebody will have to file a motion for it. Tried to work it out, but it's not. So I'm denying your request for a change of custody. And that's it. If I were you, sir, I'd go talk to a family law attorney. Good luck, everybody. Thank you. We're adjourned. The matter of Bantland versus Leader. The plaintiff is present with her attorney, Mr. Vanden Heuvel. This is a request from the plaintiff to enter an order from a hearing that we had on May 5, 2023. An order has been presented, and I've also got the transcript from that hearing to kind of go through it. And although they had 39 motions to prepare for and didn't really want to read a transcript, I did. Okay. So the order that has been presented to me presents yes and no. There are some things in there that were not in the agreement that was put on the record. Parenting time was clearly on the record. He was getting every Wednesday and Saturday from 9 o'clock till 11, and his parents had to supervise. That's correct. I think it's appropriate that the holiday time was in there also, although I don't think it was directly put in. It's to his advantage to get parenting time on the holidays, and it's still to be supervised at least until some other time of that we get to. There's nothing in the transcript about, I'm trying to find, I marked one up here. And so there's nothing in there specifically about the alcohol and drug use, although I can't imagine why that would be a problem since it kind of states common sense. Mr. Vanden Heuvel, is there anything you want to say about that?
No, we just put it in because there is there is abuse of marijuana here, although it's legal.
Yeah, it's legal.
It's clearly a concern in terms of there's been mental health issues and so forth, self-medication thoughts. going on here. Obviously, we just don't want it to be during the period where there could be secondhand smoke exposure to the child or of marijuana or misuse of that substance during parenting time. Like you said, it seemed very common sense, and given that there has been mental health issues in this matter, that obviously was the reason that was.
This would be a lot easier if he were here, but we're trying to enter an order from them. And I mean, if he was here, I'd tell him that's probably what I was gonna do, but I hesitate to enter an order that was nothing that was agreed to on there. I don't have a problem. But we do that paragraph, neither party shall misuse or abuse alcoholic beverages, prescription medication, blah, blah, blah. Through the line that says use of any illegal substances is prohibited. I'm gonna have to scratch out the rest of that because it was not there. Not that I don't agree with it. I do agree with it, but it wasn't put on the record. So it's.
Yeah, I understand, Your Honor. Thank you.
Again, I sympathize. Seems to me, I don't know why, I can't find the one that I thought that there were certain things. Up to that point, I believe everything is agreed to or common sense. Transportation, so long as the parties live less than 30 minutes apart, the parent whose parent shall pick up the minor child. I can't remember now, was that in the transcript?
I don't exactly recall, but just to be transparent, Your Honor, the other side doesn't have a vehicle, and my client has been doing all the transportation. So, and I don't anticipate that he's probably gonna have a vehicle anytime soon. So, I just always put a split.
And I really
natural,
sympathize with you, Mr. Van and Hubel, and don't find anything that you have done to be anything other than ordinary that I did when I was practicing that too. But because he's not here and because we have a straightforward transcript, I think we can, I'm going to take that out because I don't think it was in there. Okay. You guys can work transportation how you work it. All right. Which might actually work to your client's advantage. It's defendant shall have additional parenting time as agreed. That's fine. Communication between the parties shall be established. Neither party is to swear or threaten. I'm about to swear right now, including emotional pleas for that. I mean, violation of this provision, party in contempt. Other than that last line, we'll leave that in because that's commonsensical. But I'm not stating one way or another. Hague Convention has to be in. Travel. That was not in there, and I know it was not in there.
Nope, it was just more common sense stuff, and I wish you would have been here because it probably would have.
Yes, but I'm taking that out. I'm sorry. Inalienable rights, that should be in all the orders anyhow. Child support. Child support, he was supposed to send you a pay stub and you were going to figure it out.
I don't think we have a pay stub, Your Honor.
And because I'm pretty sure I said in there, he was to provide you a pay stub and you were going to send through a UCSO, maybe even on a 7-day, but
yeah.
Why don't we leave that in and I will refer it to the friend of the court now.
Thank you.
So, Tracy. She's been here going at it since 8:30 and I just lost her. She's got it face down on the desk right now sleeping. But she's back now. I woke her up. To the friend of the court for child support in this case. Okay. Got it. Domicile is correct at all times anyhow.
Yep.
However, there was no agreement that from the section on that the parties hereby agree to first attempt mediation. I'm taking that out because it just wasn't in the agreement. Should be, but not. Dependency exemption, plaintiff shall be entitled. There was nothing said about that, although you and I both know that she gets it because she's the one who has 99.9% of the custody. The IRS code calls for it, and maybe when we enter a final order on this, we'll get it to you, but the IRS code will dictate now, and quite frankly, I'm not with the IRS, but I know she'd get it. I think attorney's fees that's fine. The other is fine. So with those exceptions and with my deepest apologies, I will sign an order of that. Do you want me to cross off and initial everything that I did and sign it, or?
Yeah, that would be easiest, Your Honor. Then we're,
Easiest for who? You?
yeah, probably in 60. Yes.
I will sign this and send it back to you. If you find out that, because I'm going to take some of these things out. If you find that, that I didn't tell you something like this, call my office and we'll see about it. But I think I've told you everything out with the paragraph 7, the requirement of the mediation, the travel of H, the last paragraph in I think it is. No, I'm going back. F and D I'm taking out. Other than that, I think this is more than appropriate, and we'll sign it.
Thank you, Your Honor.
Get copies back to you. Now, if you wish to say anything for the record about how I screwed this all up, you're welcome to it. I'll let you put it on. Otherwise, we're adjourned for the day.
Then we have that order of affiliation we had put a motion up for too, to get that signed as well. And that's just straightforward.
Did you provide that to me?
I think we did. Hold on.
Because as I recall, there's already an AOP in this, but I said it's like belt and suspenders. If you want to send, I didn't see an order of affiliation.
Nuts. I did send one in on April 18. Oh, I'm sorry. That was.
If you want to send me an order of affiliation, it is just that without a bunch of other things on it.
Yeah, it just says the defendant is father, date of birth, issues of custody and parenting time are reserved for further hearing. Parties are referred to front of the court for a child support recommendation with the order effective June 1, 2023. That's it.
I'll sign that.
Okay. I
just don't have it. I'm sorry.
Nope, I'll transmit it over right away today. We'll get that right over to you because we did send it in. I don't know what happened to it, but
all right. I'll take the blame for that. Good luck. Is there anything else?
No, this is it. Just done. We've really appreciated the help, Your Honor, and I think this is in a good place.
Thank you very much. Thank you. You were nice and quiet and sat there. Is there anything you want to say about what a good job I did or anything?
I mean,
no, she's shaking her head no, so
I don't have much.
No, I don't want to say that. Good luck, everybody. Sorry.
Thank you.
Good seeing you, Mr. Vanden Heuvel. It's been a
You
while.
too.
Both parties are present. The defendant is present with his attorney, Mr. Visser. This is a motion to modify parenting time and child support. Oh, wait a minute. Doesn't do me any good. I got the wrong notes in front of me. So it's been a long day.
Nope.
All right. There's a motion by the defendant to enter an order, say the parties agree to the parenting time change, which is father now has 4 overnights, mom has 3 overnights. Also says that I think the parenting time order and child support should be set according to the submitted UCSO. Dad pays $123 a month. Is this stipulated to, or ma'am, do you stipulate to this order?
No, I do not agree to it at all. It just happened because of a stressful time where my husband almost died of asphyxiation due to 2 emergency room mistakes. And then he had to go to my son's graduation, which every year there's a graduation because I have 7 kids. And my parents are the church that Randy goes to and that I used to go to for most of my life. It is operated like a cult. So my parents have parked their camper at his house for the last 12 years. My family invites him to camping trips, not me. It's a cult. Okay. So probably because I felt sorry for Randy, because I was the one that got him into it in the first place, because I grew up in it. And when I got married, I wanted him in it. Okay. Then I realized how abusive it was. And if you go to,
You don't agree with this order then, right?
I'm sorry. Right. No, I don't.
All right. Mr. Visser, if it's not really a stipulated order, I can't enter it. Are you asking for a modification of parenting time then?
Yes, Your Honor.
And your client has had, Caleb's 15 years old, so, has he been staying there for 4 out of 7 nights or what?
Okay. For the first 15 years of his life, he was here full time. Okay. And he went to Randy's on the weekend. Then there was an issue where people got angry at my at my husband because he kind of got very upset because for the 12th year in a row, he was shunned by my parents at Caleb's 8th grade graduation. And so he said some things, and then my kids all pulled Caleb over to their house and said that they didn't want him there. My kids did. And then what happened was—
Where's Caleb living now?
He's been living at my house and Randy's house. And that's, I mean, I guess I don't mind if he wants to live that way. I don't care. But the point is, I want to have equal time. So I want to be able to take Caleb to my church, because that's the whole thing with that church. I'm a Christian. Okay. I'm a Protestant Christian. And the problem with that church is Randy doesn't want me to be able to take him to the morning service of my church. And I haven't been able to take Caleb to the morning service forever. And that's why I want Caleb to stay overnight, one more night every other week, so that 2 Sundays out of the month, I can take him to my morning service, because the Protestant Reformed Church has 2 services. My church has 1 morning service, and then it has a Bible study in the evening. It's not the same. And so their whole group, they're so sticklers with like not letting people go to other churches.
I'm telling you right now, I'm not going to make any rulings based on any religions. All right.
Okay,
this is not a court that is involved in religion. All right.
Okay. So I want Caleb Saturday nights every other week.
You what?
Everything is fine with the system that we have going on now. And I even tried to settle with Randy out of court. I said, I just want Caleb 4 days a week. You have him 4 days a week. I mean, every other week.
There's only 7 days in a week.
Yeah, every other week. So every other week, I want him 4 days a week. And
which 4 days?
I have him Wednesday, Thursday, and Friday now. And what I would like is Wednesday, Thursday, Friday, Saturday, so he can go to my church in the morning. And then
every other week, and then he'd have him Wednesday, Thursday, Friday, or he'd have the other.
Yeah, like he normally does. And then I just wanted to ask this, that I am allowed to take him on my Sunday morning to my church, and he can be returned to Randy's by Tuesday.
I told you, I'm not going to get involved in it. I'm going to tell you that it's going to depend on who has the child on Sunday mornings.
Okay, so all right.
I don't want to get involved in anybody's religion. It's their personal belief. Mr. Visser, can you help me out on what I mean? She basically wants to split 50-50. I don't know what else to say. If you guys can't agree on it, I guess I'll have to. I don't want to have a evidentiary hearing on it. Do the parties agree? I mean, the last UCSO had dad with 104 overnights and mom with, and now he's asking for 208. That's clearly a change of circumstance or proper cause that we have to go through and all this kind of stuff. Is there a way? How about we send you two to mediation?
Yeah, I mean, I'm fine with that. I tried mediating with him already. I mean, that's what I'm asking isn't much.
Your Honor, Mr. Valberg would go to mediation. He'd agreed to go to mediation. I don't know if a friend of the court review might be another possibility, but
that's long, and I got to find a proper cause or change of circumstance to really, if I'm going to, your request because of the prior is actually falling into a custody change. All right, just what it is. I would like, there seems to be, these people are close on stuff as it is. Okay, 3 or 4 nights, 3.5 nights for each or stuff like that. I would like to see you choose a mediator, maybe Mary Benedict or something like that, to go to. Ma'am, you're saying a mediator, but I don't think you went to a mediator for it. You just tried to work this stuff out. And somehow, I understand what you're asking for, but Mr. Visser, help.
Your Honor, we would agree to go to mediation with Mary Benedict, and I guess if Ms. Caston's not represented, the parties could go individually. I could go with him, whatever, but we would agree to go to mediation. I guess I would request in the interim that there be a change of temporary order then to say that it's going to be what they have been doing. He has Saturday evening to Wednesday, and she has Wednesday to Saturday. I don't think there's any dispute that that's what they've been doing for a period of time.
Just since June, of last year, because of that.
Since June of last year, that's what's been going on?
Yeah, because of that situation. And I am so busy. It's like, and they had to work things out because they were mad at my husband, their stepdad, for a while.
Yeah, the only thing I'd be doing is making that temporarily, and believe me, it's temporary because I'm not gonna change custody or anything. I'm putting in an order what is being done. You go to mediation. If it doesn't work, you come back here and because quite frankly, right now, I could probably find proper cause change of circumstance. Since last June, there's been a significant change in the custodial arrangement. And I don't care what the reasons are. I don't look at those. I'm looking at the fact that there has been a change and that the father now has more overnights than you do. And that would meet Vidvarka for proper cause or actually for circumstance.
Well, yeah, they're not mad at, I mean, everything's going well for stepdad now. Everybody's forgiven him. Everybody's fine with him. But
prior to having an evidentiary hearing regarding a change of custody, which is really is necessary, I am only going to state that I will do a temporary order, not changing custody at all, but setting parenting time, what you have been exercising since last June. That's a long time. If it had only been a month or two, I wouldn't hold you to it. But since last June, all right. Then the other part of the order was it will be referred to Mary Benedict for mediation. You can go to mediation, see if you can come up with an agreement. If you can't, Mr. Visser, you can renotice this for basically a change of custody if you hearing, and I'm most likely going to grant it just because it is what it is. And then we'll have to have an evidentiary hearing on a 15-year-old kid who will be 16 probably by the time we have it. And we'll be telling him where he wants to go anyhow. But
now, excuse me, sir, Your Honor, are you a judge, by the way?
I'm a referee.
Okay, well, Your Honor, I just wanted to mention one thing. It kind of does matter that there has been so much emotional and spiritual abuse from that group of churches, the Protestant Reformed Churches of America. It does kind of matter. You might want to look up xprc.freeform and you'll see all the people that have been abused.
Ma'am, I am not getting into any religious stuff. I am not going to look it up. That's not what I'm going to do. If we have an evidentiary hearing and you wish to try and present something, it'll never probably be able to get in, but it is not what I'm going to do. All right. You can bring in proofs. You can do all that kind of stuff. I'm not there. That's not my job.
Okay.
To look that stuff up. Mr. Strictly, the temporary order does not change custody. You can put in there that I find that Varka has been met, although I'm not setting an evidentiary hearing now until the parties have gone through mediation and mediation has failed.
Okay, I can draft that order, Your Honor. What about a request for a change in child support?
I will reserve. What is his child support now?
900 or 3,000. I think it's 900 and something now, Your Honor. And I don't know Ms. Carson's income, but I imputed to her $20,000 a year, and that came out to $123 per month.
All right, my taxes are $17,300, so you know.
Well, but I mean, is that after deductions? I mean, what is your W-2 salary?
Mine?
Yeah.
Okay, I didn't finish this year's taxes, but that's before deductions.
I guess I'm going to reserve the amount of child support, although we will temporarily, I will reserve child support, and it can be modified as of this date, you know, as of the date of filing of this motion. And I guess I'm going to wait and see if I need an evidentiary hearing on custody, which should not take very long. You should be able to mediate this within a month. Okay. And if it is not going to be agreed to, then and you can I want to give him some break because it's going to be 4 and 3 for a while. And at that point,
it's been 4 and 3. She testified since June, Your Honor. Maybe we don't go down to 123, but Could you at least give him some break and then we can reserve it and we can go back to the date of the
Right.
filing of the motion?
Cut him what is basically at 400.
Okay, thank you, Your Honor.
And then I'll reserve final judgment on that until we figure out what's going on beyond
Correct.
this.
I understand.
All right, man,
So-
do you understand what I'm doing?
Oh, yeah, I mean, half of 900 is 450 though. I mean,
Well, all right, if you want me to get technical, I'll reduce it more than half to 400. I'm just picking a number because otherwise you may end up owing him money back.
Oh,
All right,
all right.
because he's overpaying for the amount of time that he's getting. Work this thing out. If not, as I say, Mr. Visser, your order will say that I do find Vidvarka. And as a result of that, if it's not going to be worked out, you contact my office. We'll set up an evidentiary hearing for change of custody because that's what you're really asking for.
Thank you, Your Honor. I will draft that and I'll submit it under the 7-day rule.
Which means, ma'am, when he sends it to me, you have 7 days to object based on the date on it. It's not whether you like what is in there, it's whether or not he did what I ordered. Okay?
Right, it's the agreement to go to Mary.
It's the agreement there. It's the agreement that 4 and 3 will continue right now. And that if there is no agreement at mediation, I will set an evidentiary hearing for a change of custody.
Okay.
All right, as well as the 400. You'll have to do a UCSO on that.
Correct.
All right, and that'll be sent to me. All right.
Very good.
luck, everybody. Take care. Sorry.
Thank you
about
very much, Your Honor. Thank you.
Thank you. We're adjourned.
Thank you.
See Jessica Scott versus Corey Conrad. Mr. Conrad is not here. Did you serve him with this paper?
Yes, I did.
All right, you have a motion for child support, but I'm not sure what you're requesting. You were at court on March 15, I think, for an order to show cause, weren't you?
Yes, and they ordered me to pay $1,000, which was paid. I was requesting for the support amount monthly to be lowered because I don't actually have income.
You didn't. But you realize that if you don't have income, why aren't you working?
I have applied for disability and I actually just had my last appointment with them on March 8th. So they'll be making a decision within 4 weeks. I'm working on it. They're making a decision about that appointment in about a week or so.
Because, I mean, unless you get some kind of doctors, you're going to be imputed income even if you don't have it. I can't just say, you say, yeah, I can't work. If there's no doctor statement saying you are prohibited from working, you got to work and pay child support. And it doesn't say that in here. I'm also going to be issued a refund check. It's on, I mean, all this talked about was how you were going to pay your past due amount. And that you don't want to be held in contempt. I get money is there. I'm just waiting for the courts to apply that to the payments. You're getting a college refund. There's nothing in the motion that asks for a child support review. When was the last child support review done?
Well, I had a motion prior to this motion and nothing was really done with it. But it's been quite a while.
October 23, I referred it to the friend of the court for a child support review.
And it's the tax refund that was actually sent to the FOC got returned to the IRS. And I am actually going through like identity issues. Somebody has messed with my identity, so I'm
Ma'am,
working with
here's what
IRS
happened.
to
I
figure it out.
referred it to the friend of the court on 10/23/23. First, in January of this year, the friend of the court sent, it is recommended that the request for support modification be denied due to the following. You, the requesting party, was sent a questionnaire and instructions with at least 14 days to respond. She was sent 2 follow-up reminder emails, but failed to provide the information required. I mean, you asked me to do it and then you didn't follow through at all.
I guess I'm not understanding what I didn't turn in, because the documents they asked me to turn in, I did give them proof of that. I went into the courts and I showed them documentation. And there is one piece of documentation I didn't have access to yet, which was the appointment for the disability and the decision that they're about to make, which I can't give that to you guys until they make the decision.
Well, I'm not going to change your child support unless you're found to be disabled. I can't. So, I mean, the motion was not asking for it, and I had done it before, but you didn't follow up, and I don't know what documents you say. I read to you the exact thing that the friend of the court sent to the court. Okay, and it was dated 1/24/24. And just simply said, plaintiff, the requesting was sent a questionnaire and instructions with at least 14 days to respond, and you didn't. You were sent 2 others. Are you saying you did respond? Because they say you didn't, and I'm tempted to believe them.
I did bring in paperwork.
Where?
Showing the appointment for my disability and the tax refund stuff and all of this. And actually, my spiritual mom was actually with me when I brought those documents in.
Okay, but stating that you have an appointment out there somewhere does not qualify. You'll have to, I'm going to deny your motion at this time. You can renew it sometime in the future if you find that you are disabled or whatever, and you have a doctor's statement, then it might be appropriate for the court to take another look at it. But I don't have anything right now that would require me to do that. I'm sorry, but your request is denied now. Thank you. We're adjourned.
God bless you.
Thank you. All right, sorry for the long wait. I've been working since 8:30 on doing these, and I don't know, maybe it's not your lucky day to buy a lottery ticket because you ended up near the end. I apologize. And both parties are present via Zoom. This is an objection to the friend of the court, UCSO, by the plaintiff mother. She said she was fired from her $30 an hour job, now working at Speedway, 1280 for 40 hours. The friend of the court imputed her to basically her last job because she was basically fired, which is you can't get fired or quit and expect to have your child support lower. She was also given 0 overnights. She said she does get overnights. She isn't, although you say you aren't getting any no overnights, and that was actually occurring that you're not. Ma'am, and he doesn't provide all his income because he's a football and basketball coach. Do you get paid for that, sir?
I do get paid for football. I have not been a basketball coach in over a year. It would be last January, and that was for a recreational organization in our town, and it was $100 for 6 weeks.
$100 for a year?
Yeah, it was for 2 weeks, but that was over a year ago.
What do you get paid for being a football coach?
Football is actually included in my pay because it is part of the school district. So when they asked me to submit, but I also was not currently being paid for football when my income was requested, my check stubs. But they had, and I did make a note, and I did let them know that all of that would be included in just my check stubs from Grand Haven area public schools.
Yeah, so you don't get paid different. It's in there, and if it is, it is, and if it isn't, it isn't.
Yeah, as of right now, I'm not being paid for football. I hope to be retained this year, but we have a new football coach, and there was nothing. It was official, but it wasn't official last year. So I'm hoping to get a contract this year, but as of right now, I do not have anything that states that I coach football.
If you are paid, it's in your regular pay stub through the
yes, yep. The ones I provided, it would have been in there, and it would have shown up on what I made for the year and everything like that. And it was a one-time payment as well. It's not something I get paid for weekly or anything like that.
All right, so that doesn't appear to be an issue here. What about the overnights, sir?
The overnights, when I talked to a friend of the courts, I did make a phone call about that. The court order that I had, it says it's worded as to be mutually
agreed upon.
Agreed
I
upon?
don't go off the court order. I'm telling you what
Yeah.
number of overnights does she have right now that she's exercising?
As right now, with the new order that they just put in after they did the income verification and all of this, she does have every other weekend with a Friday and Saturday. But when they asked me, no, just the one, just our youngest, Eli. The older two are 17, almost 17 and 16, and they refused to go. And then the referee we spoke to about coming to some kind of agreement on time did agree that they do not, if they choose not to, they do not have to go over. So it is just our son Eli that is on the
one of the kids has 52 overnights every other week.
Yeah, every other weekend. Yeah, if that's what it equals out to be. Yep.
Ma'am, I'll hear from you now.
So, Your Honor, there was a few things that I wanted to dispute in the recommendation for the support review. So the overnights, it's court ordered that I have 56 overnights with all 3 of my children.
It doesn't matter. I just told him, it's what you actually exercise. You could be given 150, but if you don't exercise them, it goes down to 0. The only thing in the court order would be that I don't know whether or not the initial is EWW or EEW or IRW, that you do have 52 overnights that you are exercising. Which one?
So it's not that I'm choosing not to exercise these, Your Honor. It's because the defendant is denying me my parenting time. So I am court ordered to have 56 overnights.
52 overnights for the one that you visit.
56.
He says you get every other weekend. That comes out to 52.
Plus holidays, sir.
Does she get a couple holidays?
Yes, we alternate.
56, sir?
We alternate holidays.
You give her 56 overnights for the one child?
Yeah, that's fine.
All right. Which one is that? Which one is that?
That would be Eli. Eli Wayne, EWW, Eli Wayne.
All right, EWW, she gets 56 overnights.
So, sir, I should be having overnights with all of my children, but the defendant is denying me my parenting time.
Figure it out some other way. I'm just telling you that when we do it from the friend of the court child support, it doesn't matter. I had somebody come in and say, I got 50-50 and the kids lived in Milwaukee. All right. And he was arguing for 50-50. It doesn't happen. It's the number of overnights. If the kids are not spending the overnights with you, you don't get credit for it. I don't care what it says. If they were spending 100 and you were only to get 56, I'd give you credit for 100, but that's not happening. So I'm going to give you the 56.
Because of the defendant.
I don't care. It's what is happening. It's the reality. They're 17 and 16 and they're choosing not to go to you. If you want to file a complaint with the friend of the court because you're not getting it, you can file a complaint with the friend of the court. If they want to put him in contempt, I'll end up hearing it. But that doesn't come into play here. I don't know how many times I can tell you that at this point. Until you get those overnights, I'm not going to give you credit for them. Yes, sir. You're breaking up. I don't know, your camera or something.
He did say that the 17 and 16-year-old had the right to choose.
I don't know who said that, but you're making it really difficult because your microphone just stinks right now. It's just vibrating. I can kind of hear it, but I don't know what. You were fine before. This is a dead issue. The kids don't go there, and so end of story. I don't know.
I apologize.
That's better. I don't know that you're holding them back. I don't know who told you that the kids can or can't go. They don't go. That's the end of this.
Yeah.
You can file an appropriate thing with a friend of the court. If it ends up something changes, we'll deal with it at that time. But that's not going to be used in here.
I have, Your Honor, and we're currently in court. We have court April 2nd because he keeps denying me my parenting time, again with the judge.
All right.
I also, so another part of the recommendation that I disagree with was my potential income. I don't think that there are quite a few things that weren't taken into consideration. I'm currently working And I am not making the type of money that I was before. So I worked for DTE Energy and Consumers Energy. I was let go from my last employer. Both of my prior employers, I learned a specific trade with them. And if I were to get that same type of job, I would have to relocate out of state. I printed off from the Michigan Public Service Commission website of all of the area utilities, and Consumers Energy and DTE Energy are the ones only in my area. I currently do not have transportation. I am currently on food stamps and Medicaid. I'm currently working. I didn't quit my prior job. I didn't switch to a lower paying job purposefully. I was let go from my employer, and I did seek other employment.
Do you agree that?
Pardon?
I mean, they didn't fire you because you were doing a great job. Something happened.
So I was let go because of excessive tardiness is the official termination. My job was relocating to Jackson, Michigan, and I expressed that I was not going to be able to relocate because of my children. And 2 months later, I was let go for excessive tardiness. So, yes, I mean,
all right,
I participated in the front of the court resources for parents program. We went to court prior to this, and I did speak with you. You told me to go get a job. I spent over 6 months trying to find some type of employment that would be like what I had previously. When I started with Consumers, I made $23.80 an hour. Out of sheer luck and great timing, I made it up to $31.54 an hour. Right now, I got a promotion. I'm making $3 more an hour. So I'm making $16 an hour. But there's not a way other than relocating out of state that I would be able to make that type of income. And that's not even guaranteed.
I will find that I'm going to send it back to the friend of the court. I probably am not going to impute the kind of money that they impute to you. You probably charge you for $16 an hour, sir. It's a matter of reality. Child support is based on numbers and number of overnights and how much you work and stuff like that. I guess I'm convinced enough that even though she was fired for too much tardiness, I'm not going to charge her as if she's making $36 an hour or something, because I don't think it's probably reality. You can dispute that at some other time. Go ahead. Yes.
Yeah. I don't understand. I just submitted the forms when I did request it to be adjusted. Because it was for years it had been she had bragged about how much money she'd made to the kids and how much.
I'm not saying you did anything wrong. You just asked for it, and I think it's probably appropriate that we figure out child support at $16 an hour. Your income.
I apologize. I feel a lot of it was too that addresses, residency, and all the contact information wasn't updated as required as well. And I think that's how it got to this point.
That has no relevance, sir.
I'll decide what has relevance. Don't tell me.
That's why there wasn't overnights for so long. I'm just saying, if it pertains, because I didn't know where she was staying. She had lost her home.
That's not true.
I'm going to send it to the friend of the court. I'm going to expect that they're going to charge her with $16 an hour for 40 hours, unless you get more in the meantime. Hopefully you do. I'm just going to do the numbers. There'll be 56 overnights for the one child, EWW or something like that. And if it turns out that she gets more or whatever, I'll deal with that at that time. But as of right now, the realities are that I'm probably not going to impute you back up to the $30-some, and we'll tell the friend of the court to, if they want to impute you, they've also got to figure you out at $16 an hour, and I'll choose, and I'm most likely going to choose that amount. It's going to go down significantly, sir, but
no, I understand.
It's the number.
I do also want to say the third thing that I brought up in my objection was the defendant's income. So he, according to the front of the court documentation, he makes $1,906.58 a month. That is a little bit less than $12 an hour. So you cannot tell me, Your Honor, being a football coach for Grand Haven High School and middle school, that is what his salary is for everything included. So he's full-time. He's a teacher's aide at Grand Haven High School, I believe. And then he also coaches. So I have multiple documents here showing he, in April of 2023, started a new job at Grand Haven High School football field. He's a board treasurer for Sidekicks of West Michigan.
He just finished telling me at the beginning how he got paid and stuff through Grand Haven.
Yes, and I'm just telling you, sir, that is a lie. There is absolutely no way that you can be a coach for multiple sports and be employed full time and make less than $12 an hour.
I'm going to.
That's impossible
to respond, but I'm not sure.
Yeah.
Did you, when they do their review, I'm assuming, what did you provide to them for the review?
I provided my check stubs as they requested. I did provide everything they requested. I did say that because I was asked to move up to the high school. I do not coach football at the middle school and high school. It is only the high school. It's freshman level. But I've only been there a few years, so I'm at the lower end of their pay scale. It is not like I do not coach college or professional football. This is a public high school. And the board, I do serve. Sorry.
No, you talk.
Yes, thank you, sir. I do serve as a board treasurer for Sidekicks of West Michigan. That is an organization that a friend of mine started for special needs kids, and I volunteer as board treasurer for him. There's no compensation for that. It is still a very small nonprofit. They're still trying to find ways to pay their hourly employees. So I and a couple other friends, we volunteer our time to be on this board of directors for now.
All right.
Sir, it says here, and I quote, I am an assistant football coach for Grand Haven, as well as a few others at different levels. There is income that he is not providing to the court, sir.
Well, show me the proof.
It is all
I'll deal with it. What?
It is all in the records I provided to the friend of the court. It is all paid through Grand Haven Public Schools.
At less than $12 an hour.
Okay.
That's incorrect. That's a lie.
I provided them.
You can bring in any proof you want, ma'am. Unless the friend of the court, they'll investigate it, but just because he does some volunteer work and stuff like that, I don't know. I'm going to refer it back to the friend of the court. Figure you at $16 an hour with 56 overnights for EWW. At this point, we'll deal with something else. When it comes out, there'll be a new order that will come out and go to both of you. What?
If I could add one last thing, I don't think that Ms. Miller took into account that over the summer, we do not have school. So I'm not teaching over the summer.
Yes, you do teach over the summer school. You do, Josh. So that's incorrect as well. There's additional income that you're not reporting to the court.
It is anything like that for like the 3 weeks that we do have summer school right after. It's called extended learning.
Why don't you just provide
both
of you. Just provide your tax returns to the friend of the court for last year. They're due
Absolutely.
15. You provide your tax returns and that'll take care of it. All right.
Absolutely.
Have you filed taxes yet?
No, I haven't.
I'm talking to
I have not either. But I can easily submit all of my info.
All right.
Whatever's required.
All right. We'll see you back if we need to after the friend of the court does a further investigation on this.
Thank you, sir.
Thank you to both of you. Have a good day.
Thank you.
Parties Wickens v. Wickens are present via Zoom. I can't hear Mr. Wickens as soon as he unmutes.
All right.
This is father's child support motion, objecting to a child support order for a couple of reasons, saying he's entitled to more time than he gets with his child. Well, that doesn't matter. You said you get 55 overnights in the thing that you put in. Mom says you get 52. They decided on 53.5 to meet at the middle. Sounds appropriate. Secondly, Mr. Wickens, your incomes were based on your last 3 years average. It was undisputed. I have seen all the documents that went in, and it appears that your income is correct in there. The overnights that you spend with your daughter are correct. I don't know what you're objecting to because it's a correct child support order.
When we originally had this meeting, and you said that I couldn't. There was nothing you could do about getting me more time with my daughter, and I gave up. I conceded.
I know. I'm more than familiar. I see you guys every 6 months. So
okay. So you said that day that when this came through that you were going to review it again, because when when we set up the judgment of divorce, I was agreeing to pay for half of everything. And then at that time, I also had half custody. And now I have no custody. And I think that child support should cover all the extra expenses that I originally had agreed to, because it's a lot more than.
I mean, you're talking about gymnastic expenses. How much?
That's $400 a month probably. And I've already paid it for the whole season. It's just, it adds up to a lot of money.
It's expensive to raise kids.
Yes, it is. And I would love to do it if I got my time with her, but I don't get half time.
That's something that I don't know how
I know, you
else
said
I
you
can say it. I
can't tie
can't
her up.
fix it. It's something between you and her. And if she doesn't want to go there, I'm not going to be able to fix it. That's a relationship that you have with her that I don't know how to tell you, but you don't have it. And it's not my fault. I don't know if it's anybody's fault. It's how old is Ella now?
She'll be 16 in June.
She what?
She'll be 16 in June.
Yeah, I mean, she's got her own life, and I just don't know what else to say. As far as the car, you don't ever have to buy her a car. End of story.
Yeah, I realize that. This is just more continuing of Michelle turning her against me, and it's hurting Ella. It hurts my time with her, but that's not a good thing to be telling doing that stuff to your kid. That she's continually pushing her away from me, which has caused this entire thing. I've had a great relationship with my daughter the entire time she's been alive until this started. And I miss my time with my daughter. I've had my daughter taken from me with this. In my opinion, I did not want to give up any time. I fought for years on this. And now
I'm not going to go through this whole thing again. Mr. Wickens, what do you expect to be done? She's going to be 16 soon. What do you expect? Do you want me to say, okay, you got to go there for half the time. We're going to send the police and pick you up and put you there. Do you think that's going to help your relationship with her? Because it isn't.
You've made it very clear there's nothing you can do, and that's why I have given up with that. I just think that it's ridiculous that now that I have no time with my daughter, I am now having to pay $1,400 a month after all the bills that I get from her.
Support is based on your income, her income, number of overnights, insurance, a couple of things, whether you have other children, this kind of stuff. End of story.
I have not seen that paperwork. I never received that email. I went to the friend of the court and they said they don't have a copy of it. So I don't know if it even is correct. I never received that first email.
What paperwork are you talking about? The friend of the court sent me, they've done a 3-year average for you.
Correct. I've never seen their numbers. I don't know if they're including my other children. I don't know what they're including.
You don't have the child support order, the UCSO that you're objecting to?
I do not. I never received it. I went back into my email, into spam, into trash. I never received that. Otherwise, this would have been done right away.
Well, I know, but it doesn't matter. I'm listening to you, and there's nothing that you have brought up that's going to change it.
So knowing our case as well as you did, do you remember why you said you would actually, this was the first case you said that you would actually look into and maybe come up with something different? Because I'm literally getting charged to not see my daughter.
Well, you're getting charged as child support. It's support for your daughter. That's the end of the story on that. How much are you spending on these extracurriculars and stuff like that?
$400 to $500 a month.
Gymnastics is $188 a month paid to Grand Rapids Gymnastics. I can send in a receipt if needed.
That's her class. Then there's the booster fees, and there's every other week there's a new hospital bill from it that she's now has to go to.
Well, that's not something that's in your order. You got to pay.
It's caused from the gymnastics. And
okay, but even if you had her, she'd go to gymnastics and end up at the same hospital.
So I didn't want to lose my daughter. You told me there's nothing I can do because you'd have to, the only option would be to tie her up or have the police get her. So you've made it clear there's nothing I can do to keep my daughter. To lose my daughter, I don't know what numbers they're using because I still have not seen them, and I would really like to see them. I think that's fair. But from the paperwork I saw, Miss Davidson makes double what I make. And
doesn't show that. It shows she makes more than you do, but doesn't show it. She makes double.
Okay, so I haven't seen that, and I haven't seen if they.
How did you know the amount?
Because they were in the very first thing you filed well over 2 years ago or a year and a half ago, when I was supposed to pay $430 a month, and now it's $800.
That's not correct either. Your Honor, this is 2.5 months past due. I'm like literally over this conversation. They took my income They took his income, they took a copy of the medical, what he pays, and this is what it's come to. And it's just a constant delay. Gymnastics is $188 a month, and she sees a chiropractor. She doesn't go to the hospital. And half of that is $26, depending on what type of adjustment she gets. That's it. And I bought her a car. It's fine. All that is just irrelevant. No, I have a receipt. Thank you. But I would like just to dismiss this because it's 2.5 months past due, and he still owes, he hasn't paid anything.
That's not true. That is a lie. And I have paid. That doesn't, friend of the court isn't fast.
Today, and let you guys argue off the screen sometime. We're adjourned. Thank you.
Thank you.
How do I get a copy of this?
Call a friend of the court.
They told me they don't have it. They said that they don't have copies of that. I went there, I went to go pay. They said that I couldn't pay because I didn't have cash on me, which that seems really out of date. Then I wrote a check and mailed it in. And so there is money. I paid from a couple $1,000s worth, whatever it is. And then I asked the lady, how do I get a copy of it? And she said that they don't deal with that. So I'm asking you.
I'll give you instructions of how to log in. I have it. It was in the letter that they mailed. I'll send it to you.
I never
personally.
received any letter, and I never received a mail or anything. So I have no way to argue this because I don't even know what I'm arguing. I don't know if
I don't know what you're arguing either. And I don't even know.
We done?
Yes, we're done. Thank you.
Thank you.
Your Honor, why did you say that you would look into this on that date?
I did. I looked into it. I just don't find it. Yeah, $100 and some for gymnastics is not over the top.
It's more than 100 and some. That's just the class. She's also on the team. If I only have to pay for the class, that's fantastic. That's less than half of what it is. But I have two other stepchildren that I pay for that it probably isn't accounting for, and I have my other daughter.
Because they're your stepchildren. I don't know.
And I have my other daughter, and I don't know if they're accounting for that. I've just never seen the money. Yeah. And this year, I sell new construction homes with the interest rate.